Shall we end the stalled recollation that's left a number of constituencies still not clear who the winner is? The Supreme Court's decision yesterday, quashing the High Court's ruling as far as it concerns Tema Central, Ablekuma North, Techiman South, and Okaikwe Central. Will that end this dispute? Cap ministers at 25, expunge deputies, and scrap regional ministers. You've heard this before. That's the Constitutional Review Consultative Committee that has been working for a couple of years now. They eventually presented their report to the president, who assured that he will pass it on to John Dramani Mahama for possible action. We'll be right back to deal with the vexed matters. Welcome back. As you know, there have been some disputed constituencies where the results have been in a struggle. There's been debates. Some of them declared, but the EC says declared under duress. The officials declared the results under duress. The EC says the officials did the declaration, some of them at gun or knife points. Some, the EC says, they were done in non-compliance with the CI 127, the Public Elections Regulations 2020. To that effect, the EC annulled them and began a recollation and a declaration. It's been sharing with us precedents to that effect beyond 2020, when it denied the NDC a similar opportunity. So Saturday, last week, 9 of the contested constituencies where recollation began for them on the back of a High Court ruling the day before. 7 out of the 9 were recollated and declared, all in favor of the NPP. There was such a tsunami, an overturning of all those results. 2 were left outstanding because there were issues pending resolution. That appears to have been ready to be resolved today. But the Supreme Court yesterday, on an application by the NDC for a certiorari to quash the orders of the High Court, heard them and quash the declarations or recollations for 4 of the constituencies. The parties must go back to the High Court, differently constituted, this time not the same judge, for the NDC to be heard, because, as the Supreme Court heard, they were denied the opportunity to be heard before the judge could give his decision. A number of issues come up. We'll answer them for you. What happens to the already declared constituencies that now are at stake? But let's go to the Supreme Court first for the ruling, unanimous by the 5-member panel.
In the processes before us, the 1st to 7th interested parties contend that the collation of results was not completed in those constituencies. It was in this state of affairs that the 2nd to 7th interested parties filed series of applications in the High Court and prayed for orders of mandamus against the Electoral Commission, which is the first interested party herein. Their prayers were for the High Court to order the Electoral Commission to undertake collation in their constituencies and to make a declaration of the winner of the constituency election. In the meantime, the applicants herein had earlier on 16 December 2024 filed an application for judicial review against the Electoral Commission, in their case praying for declarations that there had been earlier declarations in their respective constituencies and praying for injunction to restrain the Electoral Commission from doing another collation. On 20th December 2024, the two applications were listed before the trial High Court judge for hearing. The first application called by the trial judge was that for mandamus by the interested parties herein. The Electoral Commission did not file an affidavit in opposition and stated in court that they were not opposed to the application for mandamus. However, Mr. Godwin Ebiji Tamaklo of counsel for the applicants hearing stood up in court and informed the High Court judge that his clients were interested in the mandamus application and that they had even filed a motion to be allowed to join the mandamus case. The judge decided to proceed with the determination of the mandamus application and granted all of them in favor of the applicants therein. It is those rulings dated 20th December 2024 that the applicants have invited this court to quash and to prohibit the trial judge from having anything to do with the applications. The grounds of the applications were as follows. I've listed them in accordance with the motion paper. The interested parties filed affidavits in opposition with exhibits as well as statements of case in which they argued in answer to the case of the applicants. Before the courts could hear the application, counsel for the second to seventh interested party raised a preliminary objection and pointed out that the rules require that at the filing of the application for certiorari, the ruling which is sought to be quashed should be attached, but that was not done. The court indicated that the application should proceed and that in the final ruling would answer the charge. Our conclusion was informed by the fact that there was an explanation in the affidavit as to why the ruling was not attached. And we took note of the fact that now the rulings are before the court, and in order to determine the merits of the applications, which have been well argued by both sides, it was in the interest of justice to proceed. So we proceeded. Counsel for the applicants first stated that since at the hearing on 20th December 2024, the trial judge was notified that the suit were affected by the proceedings for mandamus, the judge ought to have joined them to the case in order that they could file affidavit in opposition to the grant of the mandamus. He further submitted that since their application filed on 16 December 2024 was listed before the judge for hearing the same day, the judge had knowledge of their contention that collation had already been completed and declarations made in 4 of the constituencies. So he ought to have permitted them to put that evidence before him in respect of the mandamus application. Now, additionally, the applicant stated that the procedure rules on judicial review in the High Court, which were applicable in the case of the application for mandamus, being Order 55 of the High Court Civil Procedure Rule CR 47, made ample provisions for interested parties to be added to an application for judicial review, but the trial judge failed to apply these provisions and to add them. Counsel for the applicants relied on a number of decided cases, especially Republic versus High Court Bolgatanga, ex parte Hawa Yakubu, 2001-2002, Supreme Court of Ghana law reports. Counsel for the applicants further stated that the trial judge exhibited bias against the applicants by not only failing to admit them into the mandamus application, but by opting to hear the mandamus application first when their application for declarations and injunctions was filed earlier in time. In answer, lawyer for the first interested party relied on the statement of case he filed and added that he observed that none of the individual parliamentary contestants had an affidavit before the court in which they complained about any miscarriage of justice. Lawyer for the second interested party, the second to seventh interested parties, stated that he was vehemently opposed to the application. He pointed out that the applicants built their case on the failure of the trial judge to join them to the mandamus application. But he submitted that the rules of the court on non-joinder of a party is to the effect that non-joinder does not vitiate proceedings. He referred the court to the case of Bobier versus 21st Century Company Limited. He submits that the judge had a discretion given to him in the application for judicial review to join interested parties if it was in his opinion. If it was in his opinion that they would be affected by the proceedings. The trial judge did not consider the applicants necessary parties and he exercised his discretion against joining them. He submits that such order would not be granted to quash the exercise of discretion by a trial judge. He referred to the case of Republic versus High Court, the Republic versus Court of Appeal, ex parte Chatichikata, 2005-2006 Supreme Court of Ghana law reports. Now, the consideration. In our opinion, the crux of this application is whether, under the circumstances that the trial judge was faced with, could he have proceeded to determine the mandamus applications with adhering the applicants in the form of affidavit evidence and legal submissions on whether the case before him, notwithstanding non-opposition by the Electoral Commission, was a proper case for the grant of an order of mandamus. It is very clear to us that it was plain to the trial judge that the clients of Mr. Godwin Edwigi Temaklu stood to be affected by the proceedings in the mandamus application. And the least he could have done was to grant them a hearing on the facts and the law upon which the application was brought. Our courts and all courts, especially in the common law tradition, have held this right to a hearing so sacrosanct that under the circumstances of this case, the applicant ought to have been given a hearing, notwithstanding or irrespective of the provisions of Order 4, Rule 5 of CI 47 on joinder generally and Order 55 on judicial review. In the case of Awuni versus West Africa Exams Council 2003-2004, Supreme Court of Ghana law report, the Supreme Court quashed a decision of an administrative body, that is the West Africa Examination Council, for failure to accord persons a right to a hearing. The statute under which the West Africa Examination Council functioned did not expressly confer a right to a hearing, but the Supreme Court held that the West Africa Examination Council ought to have accorded those affected a right, since the right to a hearing had been elevated to a constitutional right. in Article 23. If that had been held to bind administrative bodies, how much more a court of law? In the case of ex parte Hawa Yakubu, the High Court in Bolgatanga made orders in an election matter which affected Hawa Yakubu, a candidate at the election. And though she was a non-party, the Supreme Court held that on the facts in the case, the High Court violated her right to be heard and quashed the orders of the High Court. The interested parties say that because Mr. Godwin Edwidge Temeklo was allowed by the trial judge to speak, he was accorded a hearing. But they must realize that he was allowed to speak as a friend of the court, as recorded by the judge himself, and not as counsel for the applicants. This is an unfortunate misunderstanding of what amounts to a hearing in the mandamus application of this nature. Hearing plainly required the applicants to have filed an affidavit in the matter and to have made legal submissions. In this case, none of that happened, so the trial judge violated the right to a hearing of the applicants. Now to our orders. We have taken note of the fact that the applicants did not contend that there had been earlier completed collations in respect of Nsawam Adwajiri and Ahafano North constituencies per paragraph 8 of the affidavit sworn to by Fifi Fiabi Kwete dated 16 December in support of the motion for judicial review filed by the applicants on 16 December 2024. Since the orders which have been brought to be quashed are separate and distinct, we have decided to exercise our discretionary power to quash Baseshorai, having regard to the peculiar circumstances of each ruling. Consequently, we hereby quash the orders of mandamus made for collation of results by the Electoral Commission in the following constituencies. 1. Okaikwe Central. 2. Ablekuma North. 3. Tema Central. And 4. Techiman South. Accordingly, the collation of results in the above constituencies by the Electoral Commission after 20th December 2024 on the orders of the court are hereby set aside. For the avoidance of doubt, the orders of the High Court made in respect of Nsawam Adwajiri and Hafwano North are not affected by this order, by this our order, and in effect those declarations stand. Despite quashing the orders stated above, the applications for mandamus themselves are still alive and ought to be heard and determined. In line with our those which have been quashed, to file those which have been quashed as interested parties. The time for filing is hereby abridged to 2 days from today. The applicants for mandamus in the High Court upon service may respond to the processes of the interested parties. Having regard to the circumstance of time constraint on the national electoral calendar, we hereby abridge the time for a hearing of the mandamus applications in the High Court and direct the High Court to hear the applications for mandamus on Tuesday, 31st December 2024. I hope Tuesday is 31st. On the issue of bias, we are not satisfied that sufficient evidence has been provided to us by the applicants. Nevertheless, in order to maintain the integrity of the adjudicatory process and in line with the practice of this court in cases such as Republic versus High Court ex parte, Agua Company Limited, Auditor General Interested Party, 2019-2020 Supreme Court Law Report of Ghana, Adare, we hereby direct that the applications for mandamus that are extant shall be placed before a different High Court judge for hearing and determination. To conclude, by the conclusions reached in this decision, release A1, A2, A4, and A5 endorsed on the applicant's motion paper are hereby granted, while release A3 and A6 are refused. Release B and C are hereby dismissed.
And that's the Supreme Court issuing quashing orders by manner of speaking in law, certiorari, against 4 of the constituencies where the orders of mandamus were obtained from the High Court and compelling the Electoral Commission to conduct the collations, recollations, and declarations in those constituencies. So 4 of them quashed. As we understood, we will find out the implications now. On Saturday, this application before the Supreme Court was pending, and a stay of execution had also been filed and served first on the police. So the police were not supposed to have provided security for the recollation or collation that happened on Saturday, but they did. What happens? What's the consequence for that? As you can also see, the Electoral Commission had filed an affidavit in opposition and statement of case in the same matter that was pending, and for which there was a stay of execution application as well. And the Electoral Commission went ahead with gazetting of the constituencies as they spoke to the press yesterday, while the Supreme Court processes were underway, that they had gone ahead to do gazetting. What does that mean? And are there any implications? Because there's already been a gazetting of those 4, will they stand, or what will happen? A new judge has to hear the mandamus application by offering the NDC the opportunity to be heard. And as you saw on your screens, the panel of 5 was led by Justice Gabriel Scott Poimang, and you had the other 4 members, Her Ladyship Justice Professor Henrietta Joy Abena-Mensah Bonsu. You also had Justice Ernest Yao Jeu, you had Justice Henry Kofi, and Justice Richard Ejay Frimpong. That was a unanimous decision. Now, let me introduce you to my guest here in the studio, and also joining us via Zoom in the studio, Clara Kwalaga Berry Kasati is Chairperson, Constitution Review Consultative Committee, that is the CRCC, who have just submitted their report to the President of the Republic, led by Osei Mensah Bonsu, who had oversight over this process. The President promised that he will hand over the report to John Dramani Mahama with notes on what he thinks about the report, but he insisted that there ought to be broad nationwide consultations to complete the process, and if the, as it were, the amendments will happen, that must first happen before any constitutional amendment. Now remember that this is the committee that informed you earlier that they had proposed that ministers should be capped at 25. They also asked that the deputy minister should completely be, scrapped. And then the regional minister's office should also be scrapped completely. There are other interesting matters that they raise. Oliver Bakavomowo joined us last week. He's back. He made a post about the heavy, as it were, burden and good opportunity handed John Dramani Mahama to do a host of things for the people of Ghana by the parliamentary majority, or call it super majority, that they appear to be getting. And that went viral. He will be telling us constitutional processes, what he thinks must happen. He's constitutional rights and policy strategy advisor of the Democracy Hub. He was with the Constitution Review Commission set up in 2010 by Professor John Evans Atta Mills. He played a pivotal role in that. Here in the studio is the Honorable Inus Afuseni, former MP, Tamale Central. He was ranking member Constitutional, Legal and Parliamentary Affairs Committee of Parliament of Ghana. He has been minister in 2 different portfolios. Of course, this process of the CRCC, Constitution Review Consultative Committee process, he has also been played a part in it. Ayikwe Otu is former Attorney General and Minister for Justice. He's a leading member of the New Patriotic Party. And then later, Osei Mensa Bonsu, MP for Suhum Immediate Parts, Majority Leader, Leader of the House, and Minister of State with executive oversight of the CRCC, Minister of State with executive oversight of Ghana AIDS Commission, Minister of State responsible for presidential affairs, and Leader Emeritus. Recently, you heard them in Parliament calling him the Supreme Leader, and that's a new title. But Charlie, the titles in this republic. Anyway, so he'll be joining us later and to tell us why this government embarked on this process on the back of the Constitution Review Commission set up by Professor John Evans Atta Mills. Ladies and gentlemen, good morning and welcome to Newsfile.
Good morning, Samson.
Great. So if I may begin with Oliver. Oliver, last week you said you found no problem at all with what Justice, Reverend Father Justice, I don't know how to put all of that together, Joseph Ajiman had done by giving the mandamus orders to the Electoral Commission that led to the recollation or collation of the 7 out of the 9 constituencies that were outstanding. You said you found absolutely nothing wrong with it. What do you say?
I think that the conversation we're having went to the substance of whether or not the EC had authority and power to recollate elections. And my view and consistent position is that once you've been given the job to collate, that job does not end by the first declaration of results. And that if you have reason to revise that, you're entitled to do that. Now, in the conversation we are having, and particularly in light of the Supreme Court decision, we ought to distinguish between what is doing the right thing rightly and doing the rightly wrongly, meaning that there's a procedural question which is at the heart of the conversations here, and which is the Supreme Court, I believe, was absolutely correct in directing and the orders that they are taking on this matter, which is that the substance on how the judge may reach the decision to order mandamus may not change, but what is sacrosanct in our democracy is the right to hearing. That persons who are entitled to be heard on the matter ought to have been given the audience to speak to this, which is what we are denied them from doing. And in fact, from the proceedings in the Supreme Court, and the extent to which the High Court judge took to ignore matters that had been brought before his attention and were pending before him, I think that very few people would have been supportive of his decision to refuse the the NDC the opportunity to be heard in the matter. Now, one of the things that we can agree the Supreme Court has done is, I believe, is a Solomonic judgment. It's a judgment that, for lack of a better word, favors our democracy and enhances the rule of law. It's the direction of a lot of people have been hoping to see from the Supreme Court in years. And I think that everybody will be overjoyed in the way in which it brought clarity and maturity to the decisions that it made. But it doesn't resolve the issue, and I don't think the Supreme Court intended to. It recognized the authority of the High Court to make those decisions and do it so rightly. And so we are back to the drawing board, in essence, that the NDC will get an opportunity to be head of the matter. But there's something important here, which for even you and I who are interested in the legal question as to whether the Electoral Commission has the legal authority to recollate, that this may not necessarily resolve because of the manner in which the court has been approached. The court has been approached on a mandamus application. And the mandamus requires that you make a showing that the Electoral Commission has either failed to collate or is refusing, after a reasonable demand has been made on it or after a reasonable time, to collate. It is surprising to me that in the High Court proceedings, the EC, even though it has not said anywhere that it is refusing to collate, went ahead and did not oppose that point. So when we come back before the High Court, that question is going to arise again, and I think the NDC is going to be happen on that, which is that there's nowhere where the EC has said it is refusing or failing to do a statutory duty. And if there's no failure to, and there's no refusal to, then a mandamus does not lie in terms of how law operates. Now, there's a bigger question as well centrally to this, which is the Commission's persistent recourse to placing the judiciary before a fait accompli, which for me is a strategy that seeks to undermine judicial oversight by putting in place what it considers to be reversible outcomes. And I'm speaking here, one, when there was a state of execution, it went ahead to collate those results. And the last week we talked about, we don't understand the rush. A rush which is not only just a rush, but is also offense law and procedure, which is that you cannot disrespect the courts when there's a pending application to stay. You can't take any actions. Secondly, and as you have pointed out in the beginning, the fact that the EC participated in the process, filed an affidavit in opposition, and yet went ahead to gazette those results. Again, another attempt to place the court before a fait accompli. This series of actions, for me, is something that we need to look at. The liberty with which the Electoral Commission continues to give itself in undermining the judicial process is really concerning, particularly when consistently trust in it is low and when people are continuing to call into question his actions. What happens next as to those series of actions, I don't know. But one thing we are clear about in law, and perhaps here we have sort of an extension of the Grun-Norm principle, that a chain of legal validity of those declared results and then consequently the Gazette has been broken. The Supreme Court has quashed those, which means that the Gazette which is based on those declarations are null and void and have no legal effect. That ought the position of them. And I know a number of people have suggested that the EC can go ahead and submit those Gazettes to Parliament, and Parliament ought to respect it. I don't think that is going to happen unless, obviously, we see what happens in court.
There are those who actually suggest that the NPP could simply withdraw this mandamus application so that on Tuesday there will not be any application to be moved because those results have already been gazetted.
And I've heard that view before, and I think that, in fact, I have made that suggestion that that possibly could happen, where the NPP could withdraw the application. But the fact of withdrawing the application does not nullify or extinguish the Supreme Court's order that the declarations were null and void. So those declarations that were made on Saturday in particular do not exist in law. The question is whether or not, and then we get back to the same point we have been going back and forth on, whether the EC is entitled to go back and recollate, whether with or without a court order. That question continues to remain alive, but for all intents and purposes, all we have now is the earlier offense declarations, which have not been nullified by any court process, but unfortunately do not have the benefit of a gazette. And in that situation, it will be interesting to see how we navigate if the MPP decides to withdraw them.
So imagine the MPP went ahead to withdraw its suit, and therefore on Tuesday there will not be suit to be debating. Is the EC under some compulsion to as it were, gazette the 4 constituencies for which the mandamus order for the coalition have been quashed, so that those people, once they are gazetted, they go into the House on the 7th and they are sworn in. Those who are aggrieved would then, pursuant to sections 19 and 20 of the Representation of the People law, proceed with a petition to the High Court.
The EC could take that approach. Unfortunately, if it does that, it means that it will be going against its own position consistently, which is that it believes that those declarations were illegal and unlawful. So that would place the EC in a peculiar position where it would then be proceeding to gazette actions that the Commission itself has declared unlawful. Now, we have to be clear that the orders the Supreme Court has made have no effect on whether or not, or does not resolve the question of whether or not the EC can proceed to do a recollation and redeclaration without any court orders. It doesn't answer that question for us. And it seems to me that to be consistent with its position that those declarations were unlawful, that it might proceed to say that we are going to do new recollations which do not owe to or do not derive from the impugned High Court orders, which is what's likely to happen.
Okay. I heard you bring up a new thing. I don't see how that does not contradict your position on Saturday. You are saying that a mandamus primarily will only lie if one has refused to perform their official duty. Today you are saying that there is no evidence that the EC has refused to perform its official duty. Therefore, the mandamus application was premature in the first place.
Now, if the party which is the respondent which has the legal duty in respect of the mandamus application was the EC, the EC before the High Court judge invariably admitted that it had failed to or was refusing to perform that duty, which assertion we know was incorrect at the time. And this raises another specter which I think NUG harped on in the Supreme Court, the risk of pollution. That if you have, it essentially becomes a fixed match. But our legal systems abhors this. That's why we have an adversarial system. And if you have an adversary, which is in fact not a proper adversary, like the EC is doing, that raises question and why it heightens the need for a third-party voice to be admitted into the conversation.
All right.
Now, if the NDC comes into the process, the concession that it has not done that obviously does not hold, because we have proved that, in fact, declarations have been done, and so the duty had not been not performed, or that it was not refusing to do that. And I think that's the situation in which we are.
Right. Let me get to Yunus of Seni before. So, what do you make? Is the issue resolved? What do you make of what has happened? And can you answer the question if the issue is resolved as we speak?
Well, I think first of all, let me say good morning to Clarity. Sometimes since we met at Kwabinya or where?
Yeah.
Yeah. And to my good friend Samson. Indeed, Samson, the issue has not been resolved. It could not have been resolved. Now, because if you look at the electoral laws of this country, it seems the Electoral Commission has led us into a situation where we are now struggling as a country to extricate ourselves. Now, if you look at CI 127, and I've read your comment, it appears to me that there ought not to have been any rush at all into recollating the results of the disputed constituencies. Because the law, the CI, which is a CI of the Electoral Commission, clearly details steps that an aggrieved candidate in an election must take and how his rights accrues. That is after the results of the election in that particular constituency has been gazetted. Now tell me, Samson, all this hula baloo about mandamus compelling the Electoral Commission to perform a duty that is imposed on it by law, which the Electoral Commission has refused to perform, or collating the results of an election, which of them could not have been achieved if we had simply we had simply waited for the results to be gazetted and the aggrieved party takes the matter to court? Which of it could not have been resolved? Now, we have been put into a constitutional crisis today because the EC appears to be the interested party in this case. And I've said when we were in Parliament in 2020, when the Electoral Commission appeared to answer questions on SAL, that it appeared to me then, and has since been confirmed by many people, that the Electoral Commission was acting as if they were a law unto themselves. Now, just take the CEI 127. Even if there's a dispute where there is equality of votes, and there's a dispute as to whether or not one vote should be counted for either of parties with the equality of votes, it is not within the preserve of the Electoral Commission to determine that one vote. It has to go to the High Court for the court to so determine. So clearly, and I've read the presser of the EC addressed by Bosman Asari. And he says, look, there was an illegality. There was an unlawful act. And we, the Electoral Commission, cannot allow that illegality or unlawful act to stand. What does it tell you?
The EC chair herself had said that earlier, that the processes in those disputed constituencies did not comply with CI 127. To that extent, they had annulled them. They were going ahead to do a recollation, and because they can't accept them.
So the EC chair says the processes did not comply. Who determines whether the processes have complied with CI 127? Is the EC? You think that EC decides that?
Why not?
No, they are not. Another party, another institution of state must so determine whether or not the EC, the processes at the polling station or the constituencies or the coalition center has complied with CI 127. Now, EC arrogating to themselves the power to so determine is what has led us to this crisis, and reinforces the perception of bias of the EC, because people are wondering why the EC all of a sudden can take so much interest in a case in which they, EC, have not alleged duress in court. They, the EC, somebody who was a party to the election, went and alleged in court that somebody or some group of people put an officer of the EC under duress. And that's why he or she failed or declared the results otherwise. The EC did not go to court.
The EC was in court and said it was not opposed to or did not disagree with these claims. Hold your thoughts there. We'll take a quick break. We'll return so that our radio audience will get the opportunity of joining us. As you know, we began at 8 o'clock, not the normal time that you have been used to Newsfile. This is the third time that we are doing so. We'll continue in this direction to give you more time, particularly during this transition era. We'll be right back. This is Newsfile. It's your most authoritative news analysis platform, and this is your election headquarters. During the period of the transition, we're giving you extra, and hopefully thereafter. Show is brought to you by the candid sponsorship of Bank of Africa, as strong as a group and close as a partner, MTN, everywhere you go. Ashesi University, educating ethical and entrepreneurial leaders for Africa. Robert & Sons Optical Services, your comprehensive eye care service provider for 33 plus years. My Way Insurance, simply dial *165# on MTN to join My Way today. DB Industries, roofing Papa Fie. Flamingo Paints, simply superior. Syntex stands, it's strong. It's tough. And Activa International Insurance. Our clients are passion. And if you're just joining us, my guests, Clara Kaseti, Oliver Bakavomawo, Inusa Fuseni, Ayikwe Otu, and Oseche Mensabonsu joins us later. And so far you have heard Oliver Bakavomawo. We have heard from the Supreme Court, the full decision yesterday that quashed 4 of the recollated results of the constituencies and only preserved 2 of them. That is in Sawama Drejiri and Ahafwano North. Because the court said there were no complaints about that they had been recollating. It was just a process that had not been completed. So the EC should go ahead and complete. Oliver, it's clear that agrees with the Supreme Court that what their verdict is sound. The judge ought to have heard the NDC before proceeding with its decision on that day. He was in court on that day. And he points out that, in fact, the principle, the basic common thing that allows for a mandamus order to be issued, as the High Court did, is that there must be a factual basis to the effect that the EC had refused to perform its official function. And there's no evidence that the EC had refused to perform its official function. Remember that the EC had told us that week that the police was refusing to give it security on the basis that it could not assure the safety of the process. So he says, on that basis alone, it looks like going forward, there's trouble. There's a new High Court judge that will be appointed to hear the matters. Inusa Fuseni insists that the EC had no role at all once there were collations and the declarations had been done. The EC has brought trouble upon itself unnecessarily. But here you were at a point where, so what happens that the EC finds that in some constituencies, at least 2 of them or so, the results purportedly declared did not contain the full polling stations being brought together. So one place there were 2 or 3 polling stations left out. One place there were in so many dozens of polling stations left out before the declaration. You are saying the EC still should have overlooked this and gone ahead to Gazette and let the aggrieved party go to the High Court to fight it?
That is why the Supreme Court has said that they are not minded to interfere into what happened in the in Sawan Eduajiri and W Kwabenya.
Ahafwano
North. Because to my mind the collation process was still ongoing. And I've heard people cite the case of Tolong, the case of Zabzugu Tatali, the case of Pru. This is exactly what happened in those constituencies. Collation of results through the pink sheets of the various designated polling stations had not been completed. In fact, in the case of Zabzugu, the place was becoming very unsafe for the electoral officers. And so the ballot box, the whole process was moved to the regional office in Tamale. In the case of Tolong, where Abdul Razak became the first NDC MP after Salifu Abdullah, Honorable Salifu Abdullah, the wind, there was no way the collation was going to happen in Tolong. In fact, the ballot papers, the ballot papers, including the pink sheets, inserted into the ballot boxes were destroyed. So they moved the process of collation from Tolong to Tamale and asked the contestants, the various candidates in the election, to produce their pink sheets. And when they produced the pink sheets, they matched them and verified the authenticity of those pink sheets and collated the results in Tamale. This is significantly different.
And this was in 2004.
It's significantly different from what has happened. Indeed, journalists were at the various polling stations, and no journalist reported that a presiding officer of the Electoral Commission at the the collation centers that are now the subject matter of these disputed elections was under attack. No journalist reported that. And police officers were assigned to those collation centers. And we've not heard the police say that they were overpowered by a marauding group of people, and that put fear in them, and so they also abandoned their duty, their post. We have not heard that report. And the rules, CIF 2127 says that if your agents, you assign agents to the collation centers, or yourself, you're present at the collation center, or your representatives, if in the event that the results are going to be declared and you abandon the collation center, that should not operate to stop a declaration being made. And so the laws are so clear that I don't think that the court, the High Court, and that's my view, the High Court should have entertained this matter, because there were so many remedies available to the losing candidates to pursue after the declaration of the results. And for me, I think that we should be very careful the path we are treading. And the last question that Oliver Bakavomawo asked is very relevant to these discussions that we're having. He asks whether the EC can recollect results without a court order. Can they? It's my view that they cannot do that. In fact, I even extended to 2020. You remember, I made a lot of comments on the EC changing the results of, the presidential elections 5 times. I simply asked whether the EC could do that without a court order. And today, Oliver is asking the same question. Now,
and the court said what? The EC could do that.
The court even didn't entertain the EC. The court didn't even entertain the EC.
What do you mean by that? The case was concluded.
The case was, the matter never came up. The matter,
that didn't go into the box.
Yes, but the court never pronounced on whether or not the EC can declare results and change the results 5 times. And Samson, this matter is very important for our democracy, for our country, the cohesion of our country. In fact, it is only by God's grace that the people of this country are peace-loving, and they have elected democracy as a form of government over any other government. The conduct of the EC, which is highly incompetent, could throw this country into a mess. And the people could rise up against the EC, and this country would be in flames. Because even with the 7 constituencies, can you imagine what the conduct of the EC could do in these 7 constituencies? Now, it has been said time and again, and particularly for Boss Manasari, that he's repeatedly said, first he said on radio that the NDC was a veritable threat to our democracy. As recently as November this year, he's reported to have told somebody that the Electoral Commission cannot hand over power to cannot allow the NDC to win the elections.
Really?
Really, yes. In fact, and the person he told that was alarmed.
I don't think this is fair.
No,
what we know about was what is on record, which the statement he made on April 26, 2019, as reported that NDC's posture a threat to Ghana's democracy. And this is what he said. I want to read it because this comes up often and we don't go to the specific statement, and sometimes he himself denies it, even though this is what he said. So he said, quote, "I think if there is anyone who is becoming a threat or a potential threat to the democracy we are practicing in our country, then I would rather say that it is the posture of the NDC. Since this new commission took over, we have noticed some of the things that have transpired. Before the Ayawaso West by-election, allegations were rife that the register was bloated, and we also noticed pictures of bloated papers. So we as a commission, we have seen a particular pattern of the NDC. So I don't see why the NDC will turn around and accuse the chairperson that her actions were a threat to democracy. This is the only commission that is committed to Ghana's democracy because we are operating within the law.
How can they operate within the law? Which law? Their law? Their law, which is in their hearts? Or the laws establishing the Electoral Commission and the various EI promulgated pursuant to the Constitution? Because we don't see what they are doing founded in the laws. We don't see that. And so, let me state that what I have said, Samson, is a matter that can be pursued, and that will be pursued. Because the person to whom he said that to is alive. And the person was shocked that a member of the EC could openly declare that the NDC must not win the 2024 elections. And that person is willing and able, anytime that this matter comes out for investigation, to appear before any committee or commission.
Right, so I will be going to the judgment of the Supreme Court in 2021 about whether or not the EC can correct errors or mistakes. There are those who argue that you cannot say doing a recollation is intended for a correction, an administrative purpose. And the lawyers for the NDC who were in court insist on that it is not something you can call a correction being done. So I'll reserve Clara for the attitude she will bring to this. Let's go to Ni Ama Ayikwe Otu, former Attorney General. Thank you very much, sir, for joining us. What do you make of the Supreme Court's decision yesterday? Please unmute your mic.
Okay, thank you. Yeah, I have done that.
Great. We can hear you now.
Can you hear me now?
Clearly, sir.
Yeah, thank you. Thank you for having me. Well, the Supreme Court dealt with procedural matters. I had made the point that one of the grounds of quashing decisions is the breach of the rules of natural justice. And it's a very strong ground anytime it is used.
That's right.
I do recall when I did the case for Dr. Pakwesi Indum when he was disqualified. It was one of the grounds I used, and he prevailed. So immediately I saw this one, I said to myself, wow, what is happening to this judge? Because if you don't give them a hearing, they will rush to the Supreme Court and tell the whole world that they were denied their right to be heard, which is also a breach of the rules of natural justice, and your ruling would just not stand. Again, I even have a difficulty with the MPP lawyers who went to court, because we all know that they are interested parties in the matter. Usually, when you have a title, the Republic versus so and so, ex parte, the applicants, then you add what we call the interested parties. So if clearly there were interested parties, why did you leave them out? Again, when the guys went to court to say that, look, although we've not been served, we've heard of what is happening. So we have applied to be joined to the action. The judge did not grant that application. But if you look at the 55 Rule 6.1, the court may, on the hearing of an application for judicial review, allow a person who desires to oppose the application to be heard, notwithstanding that the person has not been served with notice of the application, and may direct that person to file an affidavit. So is the judge saying that he is so unfamiliar with this regulation, especially having regard to the fact that the right to be heard is so sanctified, so held sacrosanct, that if you breach it, you are going to run into difficulty. So all that the Supreme Court has done, in my view, is to say that because the people were not giving any hearing, well, we are going to quash the decision you make, but then the mandamus is still alive, and you can go back to continue with your hearing. At this stage, that the NDC will now be, or the affected parties will now be given the right to be heard by filing their necessary affidavits. They've been given 2 days to file whatever it is for the others to also respond, and they have breached time for the hearing by 31st. So the Supreme Court did not decide on the merits. The thing with the Nsawam Ajiri and Afuano is a little problematic, in a sense that what they are saying is that the thing took place and it was concluded. So that ends the matter. But it seems to me that the main point they were trying to make is that there was no objection from the NDC itself on those 2 main issues.
That's correct.
They didn't think that anything arises for discussion. So no party really has won anything. You are going to start all over again. If you want me to stop here, fine. Otherwise, I've listened to the rest and I can continue to make more inputs.
Right. So, and let me quickly bring this so that we don't go too far. When the issues of corrected figures for the presidential election came up in 2021 in the Supreme Court held and relying on Article 297 said that where a power is given to a person or authority to do or enforce the doing of an act or a thing, all such powers shall be deemed to also be given as are necessary to enable that person or authority to do or enforce the doing of the act or thing. So to that effect, they held that for the EC to have detected an error and to proceed to correct that error, there was nothing wrong with it. It has also been argued on behalf of the petitioner that the chairperson of the first respondent could not have on her own corrected the error she made without consulting the stakeholders of the 2020 presidential election. The court said no statute or regulation was cited to us by counsel for the petitioner for this submission, and our collective industry has not revealed any. This submission does not find favor with the court in view of Article 297 of the Constitution.
The implied powers.
So the court held that what happened was an error, and the EC can correct an error. Now, so the matter that is coming up now is that what do you make of the point that first you fault the lawyers for not having themselves included the NDC or the affected parties before the High Court? But yes, what do you make of the claim that the EC had not refused to perform its official duty, and therefore there cannot be a mandamus because it had not refused?
Well, I disagree with what Oliver is saying. I had the opportunity to handle a matter, the Republic versus the National House of Chiefs, Kumasi, expert in Lardy and others, where there was no prior demand and no refusal, but a mandamus was granted. I made it my prime point in going to the court to have these things quashed. The Supreme Court said no, in view of Article 23, which seems to have imposed a duty on all administrative powers, bodies, to adhere to their own rules. When you do not follow the rules, it gives the person who is affected a right to come to court and to seek redress. So as far as they are concerned, in view of Article 23, even when the person did not request and there was no refusal, what the court did was okay. So I will remind counsel and others to look at that report, Republic versus the National House of Chiefs, Kumasi, expert in Nilabi Mensa, and that is 2011. That is what the Supreme Court said. There's so much a responsibility on you to go according to the rules that or the laws that set you up, and you cannot do what you like and claim that somebody must have to make a request first. That even if no request was made, even if no refusal, you still are under a duty to perform. And so they went ahead and upheld what the High Court judge did.
We are familiar with the ex parte Alhaji Collins Dauda case, in which the courts effectively said that in a parliamentary election where the electoral process have been substantively carried out up to the point where a candidate has been declared elected, then, that will be valid and a petition can be brought to challenge that. So do you think in the circumstances, what the Supreme Court has done now, the status quo ante has not returned, so that in these 4 constituencies, these people are duly declared and the EC doesn't have the power to do a recollation?
I do not agree with this issue whether or not the EC has power to do recollation. I don't agree with those who say the EC has no power. I'm looking at the constitutional provisions as against the CI 127, which is a subsidiary legislation. And looking at Article 45, it reads that the Electoral Commission shall have the following functions: C, to conduct and supervise all public elections and referenda. Now, at the end of Article the CI 127, you find that it is the EC which must gazette the results and forward it to Parliament. We are not talking about any returning officer acting. We all know that the EC has a small number of permanent workers, and that around elections, what we do or what they do is to employ or recruit a lot of temporary workers. So this staff cannot be substituted for the EC itself, as if they are those who have the final say on the matter. They are supposed to work under the supervision. Even if you look at the regulations dealing with the returning officer, he works under the supervision of the district election officer. You see, so at the end of the day, everything comes back to the EC. And when you are suing, you don't sue any returning officer. You always sue the EC for something that you think has not been done. These are people who go to assist them. And so, in my view, so long as Article 45C has not been amended, that it is the Electoral Commission that shall, the functions include the conduct and supervision of all public elections, they have every right to look at it. They cannot sit down. We have all said that where there is fraud, it destroys everything. Fraud is not different from dishonesty. We are told that the returning officer can only collect the results from all polling stations. We are being told that in most cases, all the results were not in. Under what circumstances did they declare the results? And you are saying that the EC should look on when it is his duty to organize these elections, and these are people who are only supposed to help. And between me and you, we know that when it comes to the recruitment, there are all sorts of things that take place in the recruitment. And so there are some who are there who are not necessarily going to do the work for Ghana, but to try and assist other people. You know that as a fact. But they cannot sit down and look on when some of these things are happening. Over 31 polling station results have not been collected, and you say somebody has been declared. The circumstances where you allow that is where you are saying that, even if we, in view of the unassailable, lead that the person has, even if you add all those that we have not counted, it will still not make any difference. So let it go on without it. But you are talking about 31. What we know of MP3, somebody winning with only 3 votes and the rest. And you are saying the EC must accept it. So, I think the Constitution should override The CI 127.
Yes, so the question will be, the court will determine what constitutes an error for which the constitutional provision you are referring to will apply. The substantive question is this, I think, and that's what is bringing up all of these debates, that you mentioned fraud. Fraud destroys everything. So who determines that there's been fraud? And that fraud destroys the outcome of anything. And what then do you make of the substantive law, the representation of the people law, section 20, which says that if there is intimidation, if there is non-compliance with law or the regulations concerning the electoral process, that has to be determined by a high court?
Well, I don't know about that, but also remember that under Article 46, the EEC should not be directed in the performance of its duties, although that does not immune it from court processes. So where there are court processes, fine, but the independence, in my view, of the NDC, of the EC, gives them that authority to act when they feel something is not being done properly. And I'm still talking about Constitution, not the PNDC law.
Okay. Now, those results that have already been gazetted, and yet the Supreme Court says those have been quashed. What happens? Example where people suggest that the MPP could simply say, well, we are not pursuing the mandamus application in the High Court anymore. After all, these have been gazetted. What do you think? How will it play out?
I don't know what the MPP or those persons affected would gain by saying that they are withdrawing, because there is so much left to be done, and it's only fair that they should go ahead and get the results collated. My brother was talking about Samson. Is it different from what has happened now in Ablekuma North, where the ballot boxes and all the pink sheets or whatever you call them have been bent? Should we go ahead and accept whatever results they have, declared when such things have happened? So please, me, as far as I'm concerned, the Constitution is supreme.
All right.
If what they have gone to, if they did anything wrong, because we all know that when cases are pending in court, you are not to interfere, then of course, what they have done will not wash. And I don't know who advised them to go ahead to do what they did. So I agree with Baka that those things, do not go anywhere. But whoever would advise them to go and withdraw the case in court would rather be doing more harm than good. Okay,
thank you. Now, Clara, so Inusa here says, we didn't see any report of people under duress or intimidation, but we saw a lot of it in some of these constituencies. We saw actually returning officers or officers of the EC making declarations in a manner that was completely absurd. Do you share the view that once the declaration has been done, it's only a third party, the court, that must come in, and the EC cannot be doing what it is doing, as in recollating and doing fresh declarations?
Okay. Thank you very much, Samson, and then good morning to your viewers and listeners and to everyone. Before I answer that question, I would like to break it in three parts before I reach my conclusion. The first one is the nature of administrative bodies. So if you look at Article 23, and I'm going to read it because it is very important. Article 23 of the Constitution says that administrative bodies and administrative officials shall act fairly and reasonably and comply with the requirements imposed on them by law. And persons aggrieved by the exercise of such acts and decisions shall have the right to seek redress before a court or other tribunal. What is important for me here is the fact that two things, they shall act fairly and reasonably, and then the second one, they must comply with the requirements imposed on them by law. There is no state agency or no state institution in this country that has the right to behave as it likes, irrespective of the law. There is no institution like that in this country. Every institution has an obligation to comply with the requirements that the law imposes on them. So the question then is, what are the requirements of the law imposed on EC when it comes to collation and recollation? So if you look at the law, I think that's where the answer is. Rather than does the EC feel that something has gone wrong, it is, if the EC feels that something has gone wrong, what does the law require them to do? Because pursuant to Article 23, they must comply with the requirements of the law. Now, the second issue is that the issue is not just that EC simply just wants to recollate. There have been some bases given why the EC wants to recollate. What are those bases? Now, what I read is that there is an allegation that there was duress, there was A, there was B, there was duress, and then
non-compliance.
Non-compliance, and for that reason, this was done. They made the declaration, which is not correct. Now, the EC cannot dismiss that allegation. At the same time, the EC just cannot take that allegation wholesale. Upon the allegation being made, the EC has a duty to act fairly and reasonably. Now, what would fairly and reasonably require them? I think that the persons the allegations have been made against, the EC has an obligation to hear their side of the story before you make a decision. Yes, it is true that fraud vitiates everything, but allegations of fraud do not vitiate anything. It has to be established. So the question, what I didn't see here is how that was established. Because I've always said that as an administrative body, when you make decisions, not everybody will agree with them. But when you treat everybody fairly and you give everybody an opportunity to be heard, they will respect it even if they are not happy. Then at least everyone can see that you tried. So for me here, the issue more is, after the allegation has been made, what did the EC do for all parties to feel that the EC was being impartial? There is an allegation. We are not going to dismiss that allegation, but we are going to hear all sides.
Is it necessary to hear all sides where we have footages where we can all see that the coalition centers became chaotic, the NDC asking supporters to, as it were, besiege the coalition centers?
Are those centers, not just other centers?
Soon after that, the NPP also said they can also go there, but they said they should go there and protect the police and the other officers to do their work. I mean, funny.
We see footages. What I want to establish is that the footages relate to this issue that we are dealing with, rather than that we know this happened somewhere else.
The EC has said, we have heard from the EC, the EC says our officers were intimidated to declare under duress, and the processes were not compliant with CI 127. That is why we cannot endorse, these are their words, we cannot endorse the outcome of what they did. We must make sure it complies before we gazette.
Well, so for that, because that particular issue is in court, I wouldn't want to prejudge it as to whether or not the EC should be entitled to that. But what primarily for me, I think, is that you look at the law provides for what should happen and where. Have you complied with that law? As from the discussion, and as we know, there's a mandamus in court. And from the Supreme Court decision, this is exactly what the High Court is supposed to determine, whether or not the EC should go and, in the cases where the claim is that collation has been done already, whether or not they should redo the collation, or in cases where it has not been done already, of course, there is not too much of an issue there, apart from the fact that, of course, the issue has been overflogged already. I was curious that there's no affidavit in opposition, so I was wondering, so why are you not doing, if you're not if you're amenable to doing what you're supposed to do, then why are you not doing it? Because I think that people shouldn't need to go through the expense of litigation to do what you have to do, if you know that that is the right thing that you have to do and all of that. Yes. So basically, yes, in short, Those are the three issues. But as to a definite answer as to whether or not the EC should be able to recollate in this circumstance, I would reserve that comment.
And why would you reserve that? Because that's not a subject before the court.
But from the mandamus...
The mandamus is to compel it to do its duty, which they say it has refused to do.
Yes, but the Supreme Court noted in its judgment that in some of the constituencies, collation had been done.
That's right.
And then in
those are the 4 constituencies
exactly.
which the mandamus has been quashed.
Exactly. So, the mandamus has been quashed. So the ones that are alive, does this include those ones, or it doesn't include those?
The ones that were not affected in Sawama, Dredjiri, and Ahafano North, they said those places the process had not completed, and so the EC went to complete them. In any case, the parties in court did not contest those 2 places that there were issues.
Okay. Personally, if you ask my view, I think that there is an issue as to whether the EC has capacity to declare illegality. Is that something within the capacity of the EC to declare that there is an illegality? There's a difference between an error and an illegality. When you say that you have made an error, you admit it's a matter of fact that, oh, I have done, I've made this error and all of that. But if you are saying that something is illegal, it's a question of law. And whether or not the EC has the capacity to make that declaration in this case is a question I think the court should answer. And then, of course, yes, so this basically is an issue of capacity.
Mm.
Yeah.
And you will not answer whether they do have that capacity or not?
No, whether they do have that capacity, it depends if the procedure was followed. For me, it's the procedure that is important. If the procedure was followed, due process was followed. Sometimes a dispute might not even arise. Mm. Sometimes somebody says, can you do that? I say, yeah, sometimes you can do something. If nobody questions it, it goes. So you could have done, you show the evidence, everybody agrees that this is not well done. Should we do the recollation? We do the recollation. But if the issue becomes a situation where there is not consistency. In the past, you say that this is the only circumstance in which we do recollation, and then in another instance, we say, and you don't demonstrate the difference. You do leave room for people to be dissatisfied.
You're still here on Newsfile. This is your most authoritative news analysis platform. And like Frank Davis did candidly last week on the show, that if there had been service of the stay of execution of the mandamus orders on the police, they ought not have gone there to the EC's regional office to assist the process like they did. You have heard Aikwe Otu, also leading member of the NPP, disagree that actually deprecates whoever advised the EC to proceed in gazetting the affected constituencies when there was this matter pending, with the EC had actually filed an affidavit and a statement in opposition, and there was actually, in addition to that, there was a stay of execution of the orders of the High Court. It's a long message, but I want to read and pick quick messages to comments to conclude this subject so we can move forward. We'll take a break and then move forward. This one says, please tell my brother Oliver, my brother and friend Oliver, that while not entirely disagreeing with his view that administrative bodies can correct or remedy errors or illegal made by them without recourse to the court, that power cannot be extended to cover instances where there is an allegation of duress or fraud, which has occasioned the alleged illegality. Whether or not there was duress or fraud is a question of fact, and the resolution of this question requires evidence, not mere allegations. Okay, Clara has just been saying this. In this particular case, where the nullification of the earlier results by the EC directly affected those who won, the requirement for evidential hearing to establish the claim of fraud or duress is imperative, and the affected parties ought to have been heard on the allegations, especially since there is no evidence that the alleged duress or fraud emanated from them. To simply say that EC can correct or remedy illegalities brought to its notice by itself without affording affected parties an opportunity to be heard is to give the EC or public institutions like the EC power to possibly collude with whomever to nullify results if they are not comfortable with the outcome by simply sitting in their offices and alleging fraud and duress. That's a serious point. Whether there was fraud, duress, or intimidation is a question of fact and must be proven with evidence. It is not simply a question of mere allegation. So in this particular case, the errors are not merely clerical or blatant breaches of statutory provisions. The EC alleges factual matters and the evidence is needed to establish these allegations before the results can be nullified or set aside. Okay, so this is from Randolph Chumisi, who appeared for the NDC yesterday as well. And these are, lawyers with views that I think are important to share. And one of them says also that if you refer to the expert Lardy Collins Dowda case, there is this implication. It is implied that that subsequent processes, namely the endorsement of the writ and its transmission to the Electoral Commission, as well as the publication in the Gazette and notification to the Clerk of Parliament, i.e. the processes in the regulations, are not necessary for the election to be complete. It can also be inferred from expert Lardy Collins Dowda that in a parliamentary election, the electoral process up to the point that a candidate is declared elected by the Electoral Commission go to the substance of the election, whereas the subsequent processes after such declaration are for purposes of record and public notification and do not affect the substance of the elections. This inference is given credence by CI 15 itself. So, for instance, CI 15 prescribes that publication through some other mass communication media may be substituted for the Gazette publication. Answer JSC in ex parte, Dr. Kofi Asare. Thanks for those. Now, what will be your concluding comments on these and the effect going forward? Let me begin here with Yusuf Saini.
Well, my concluding comments are just directly in opposition to what Ni Ayotu said when he just referred to the dry bones of the Constitution in Article 45. To say that because Article 45C gives the Electoral Commission the power to conduct and supervise all public elections and referenda, that overrides CI. Now that's a function of the Electoral Commission. And so Article 50 says that it is mandatory for the Electoral Commission, and let me read it for the benefit of our viewers. And now Article 51, it says the Electoral Commission shall, so mandatory, by constitutional instruments, make regulations for the effective performance of its functions. That is the functions under 45. It's a requirement under this constitution or any other law, and in particular for the registration of voters. You can't say that because the Electoral Commission shall compile the register, they don't promulgate a regulation to show how they are going to do it. That is the essence of the rule of law. That people must know how they intend to exercise their powers under the Constitution. Now, voters, the conduct of public elections and referenda. So it is the Electoral Commission in exercise of the powers vested in them by the Constitution and pursuant to Article 51 of the Constitution that promulgated CI 127. And so you cannot just throw CI 127 under the bus. It derives its authority from the GRUNOM, from the Constitution. And that exercise of power by the Electoral Commission is consistent with Article 45 as spelled out in CI 127.
Your point is?
The point is the Constitution details how that power must be exercised. And that exercise must be in tandem with the law, the Constitution, or any other law. And that is consistent with what we all know, the rule of law. That people must not have unfettered discretion in the exercise of their powers. The boundaries of their powers must be defined by law.
Right. So you understand that the NDC is only going to be heard by the new judge in the High Court. And the new judge could well affirm the decision of the High Court judge that the EC should go ahead and for those 4 constituencies, there should be a recollation?
Well, I have described what is happening as a crisis. Because we now have a situation where somebody or some group of people were declared. Now, if they had waited, they would have gone to court to produce evidence clearly showing who won the election and that they won the election. They could have done that with duress or without duress. I mean, for the duress being a matter of fact arising out of common law practice, not by statute. It's common law. Now, so if they even wanted to allege duress, I'm of the view that they could do that together with their pink sheets to show that the elections were won by them. The second thing is, now they haven't been declared and the results have not having been gazetted, no right was then conferred on the losing parties to go to court to vindicate their right of being declared winners of the election. Now, the Electoral Commission, in their haste to collate, have collated and pronounced, declared that. So there's a second declaration, and has gone ahead to gazette. Now, what happens? The Supreme Court says no, because of the violation of a fundamental right, a right to be heard. The recollation of the results cannot be allowed to stand. What happens with the Gazette? Does it operate? I didn't hear any consequential order. Does it operate to nullify the Gazette? If the
I thought that's clear on its face.
Well,
because the court is supposed to hear. Because there's been a quashing order, quashing the orders that allowed that to happen. So it doesn't exist anymore.
So it doesn't exist.
So we are back to the status quo.
Where those
NDC MPs had been, however, declared as winners.
So if the court hears the Bandamu's application,
yes,
and goes ahead to say, look, we don't think that, because duress is a question of fact, and
right,
that has been stated severally by you. If they don't see duress and cannot compel the Electoral Commission to do otherwise, then the Electoral Commission will have to gazette the seven MPs who are now...
So it's possible that at the end of the day, the new order, potentially on Tuesday, will lead to a recollation again.
It's possible.
Okay. Yes, Oliver, what will be your concluding comments on particularly going forward and resolving this?
I think that we are going to be in this for a very long time. I don't think that what happens in court on Tuesday is going to resolve anything, and that the other issues will come up right after whatever court decides. But one of the things I want to bring emphasis on is the reason why we are in this situation. In the last election petition, this very issue has to questioning or interrogating the work of the elections manager and electoral commission came up, and the electoral commission was shielded from scrutiny. And the resolve or the understanding then everybody got away from what happened was that elections are won at the polling stations. My view then was that that was dangerous for our democracy, and that it would lead to precisely what we saw happen in this election, that the parties then feel that unless we get our supporters to mass up at polling stations, the elections are going to be stolen from us and would have no recourse. It is not good for our democracy that we make participants in the elections feel that it is up to them to secure the integrity of our elections. This is why we are here. Now, unless we can resolve that question, unless people can have greater confidence, one, in the EC, and feeling that, well, whatever happens, we can go to get court and get an expeditious decision, they need to hijack the process or to mass up at the polling stations will not dissipate. And finally, we cannot emphasize enough the need for the EC to be consistent in the way in which it applies law. Because you cannot continue to continuously change your positions. And if you do that, you will diminish integrity or belief or trust in the process. And we are continuously going to be involved in this situation that I think Honorable describes correctly as a constitutional crisis. That's my last word on that.
All right, thank you. So, Honorable Ikoyotu.
Yes.
So, we have a resolution. We have a resolution, don't we?
I think that the undue vilification of the EC is uncalled for. as we have all agreed on this platform, we are all lawyers, that there are laws by which they act, and therefore we can only fault them if they are doing things against the law. This whole idea of they doing a recollation without inviting the other side is not true. They were all invited to come and to bring whatever pink sheets, as we used to call them, are available for the collation to be made. The important thing is that it's not necessarily due to they proving any intimidation, but the fact that the coalition did not end before declarations were made. And so we know that there were about 31, and other places there were more than that, which had not been collated. Why should we then rush? And I'm happy that Vamavo talks about this massing up. I have spoken about it. Things were going fine until somebody called on supporters to go and mass up at the pollution centers. And then all the confusion, then arose. So why don't we allow the EC to do its work? In all places where we did not have difficulty, the coalition was done. Why is it that in certain places we went and created a mess? And all the EC says that bring us the pinches and let us collect everything once and for all in the presence of your own representatives. That was what was done. They were all invited to bring whatever documents they have for the coalition. It was done. Please. For example, this talk about Dr. Bosman having said something. We are here talking about the right to be heard. I don't think that he's been given the right to be heard. So let us go slow on some of those things and allow the EC. I mean, the democracy is growing. At a point, if you recall, Samson, they came and gave money and said, if you don't vote, you are going to die. After some time, the people say, you lie back, we'll chop your money and still vote against you. That is how the democracy and things, we are growing as a nation. And so some of these difficulties will come here and there, but allow the systems to work.
Right.
Allow the system to work instead of always vilifying them.
All right. Clara, your final comments, and Kweku asks questions. So are we being told that a constitutional body, in this case, the EC, should not ensure its officers and its processes follow the law governing their functions, and that the commission is stopped from taking any administrative action when its officers report that they were prevented from following the law in the conduct of their functions? To Clara, why should a body not have the capacity to determine their capacity? They can't read their governing law. Should every decision of a constitutional body be referred to the courts?
No, but the question is not, what I said was that when you declare an illegality, there's an issue as to whether you have capacity to declare an illegality.
That's right.
Now, we have to differentiate between collation and recollation. Is the case being made that collation was not completed, and so we are completing collation? That is completely different. Nobody can stop the EC from collating. They're two completely different things. So if the EC is saying that collation was not completed and we are completing collation, I think that is completely understandable. Now, it is a different thing if the EC says that collation was completed. However, upon second thought, we have decided that the completed collation is illegal. And so we are going to do recollation. The reason is because the same EC has rules governing recollation. Now, the second question is, what do those rules say? So it is not mere illegality. It is what I think that if the EC is saying that we are not done with collation, I don't have a problem with that.
I think there's no argument about that.
Exactly. So it is if you say you are doing recollation, what do your rules say about recollation? And it's one, so you will have to comply with your rules. Now we must acknowledge that generally in life and in a society, there always comes a time where something may happen that your rules did not anticipate. And when that happens and your rules have not anticipated, your best bet is the rules of natural justice. So at that time, you will have to do something. You can't throw up your hands in the air. But I think as an administrative body, you will do something, and you will do right if you just comply by the basic rules of being fair.
Don't let Kweku's question take over your final comment.
Yes, it's being fair, candid, and impartial to all parties. So, but that actually ties into my final comment, that the EC, we have to admit, has not enjoyed a lot of credibility going into the elections, and it hasn't been new in our democracy. It is the more reason why I think that the EC must really, really work hard to make things very transparent. If there was a lot of transparency and people can follow what is going on, I don't think there will be the need for people to mass up at the coalition centers. We can't, I think we were running away from the issue if we just tell people that don't mass up at the coalition centers. The question is, why do people mass up at the coalition centers?
Suspicions of cheating.
And what ends the suspicions? Transparency. So I just think that there should, if we can work more, especially in this digital age, to make things very easy for people to follow and for people to see that the EC has no interest in the election. The EC is not contesting the elections, but the EC does have an obligation to conduct its affairs in a certain way that is beyond disrepute.
Thank you very much. And this is Newsfile. It's your most authoritative news analysis platform. We'll go into the second segment shortly, and this segment has to do with the Constitution. Honorable News of Sydney has been referring to it as the GRU norm. Right. What is happening to the Constitution? In 2010, Professor Mills asked for a Constitutional Review Commission. They did their work, presented their report in 2012, and there were processes to ensure that those were done, they were not done. There was a court case that eventually took us a couple of years down. And today, there is a new report that has been sent to the president, and the president has given the assurance that he will submit it to President Mahama, and together with his own notes, including especially that there must be comprehensive public buy-in before a process to implementing the recommendations. Remember, this is the committee that says cap ministers at 25. 25 ministers is all that we need in this country. Bawumia was promising 50, and John Mahama is going to do 60 because that was his promise. They also were proposing the expunging of deputy ministers as well as the scrapping of regional ministers completely, among other important issues as far as the Constitution is concerned. We take a break. We'll be right back, and Oseche Mensah-Bonsu joins us. This show is brought to you by Bank of Africa, strongest group and closest partner, MT and everywhere you go. Ashesi University, educating ethical and entrepreneurial leaders for Africa. Robert & Sons Optical Services, your comprehensive eye care service provider for 33 plus years. My Way Insurance, simply dial *165# on MTN to join My Way today. DB Industries, roofing Papa Fie. Flamingo Paints, simply superior. Syntex Tanks, it's strong, it's tough. Activa International Insurance, our clients, our passion. When we return, Clara will give us a peek into what the committee has come up with. And then Oseche Mensah-Bonsu will tell us the process and the importance of this, why it has not been left. We'll be right back.
Yes, it's been gazetted.
It's been gazetted.
It's been submitted to
Parliament.
Thank you.
Today? Not today.
No, not today.
The 274 has been gazetted and presented.
Those places are Recollation. They are saying
So you
that
can go to the Ghana
officers
Publishing Company for a copy.
One of the early things that I think I want to do is, one, to begin again the process that was started by Professor Mills in respect of the constitutional review. it stalled at a certain point, and for the last 8 years, we haven't moved it anywhere. I think that the time has come for us to look at our constitution again. It has served us well, and I still believe it's one of the best constitutions any African country can have. But after using it for several years, we realized that there are a few parts that we need to tweak so that it can serve us for even further generations to come. Okay. And so one of the things that I intend to do is to hold a national validation conference where we would bring all stakeholders in a form of consultative assembly. The legal people will know how to phrase it so that we can move it forward. Now what we want to do is to bring the Constitutional Review report back to this validation conference. There might be things that we flagged that we wanted to amend that might not be necessary again this time. And then by the new things that we didn't really take notice of, that will become important for us to include in the review. I mean, for instance, if you take the impasse between Parliament and the judiciary, nobody anticipated that a situation like this would arise. But once it's arisen, we must clearly state what the mandate of the Speaker is so that it's unambiguous, so that nobody has to go to the Supreme Court to seek interpretation about what the Speaker's role is when vacancies occur. So these are some of the things that I think a validation conference like that will help to streamline. And once we've done that, we can separate the two amendments. We have the entrenched clauses and we have the non-entrenched clauses. The non-entrenched clauses are easy to pass because it just has to do with Parliament. And so once we all build a consensus around the non-entrenched clauses, we can send them directly to Parliament. The entrenched clauses are going to be more difficult, but we need to build a consensus around them. They are more difficult to amend because you need Parliament to validate it, and then you need to go for a referendum to the people. And I believe that if you look at the standards that our Constitution sets for those referenda, no one party can pass through any such amendment. And so we need to build a consensus with our colleagues, you know, a bipartisan consensus with our colleagues on the political field, and get also the support of the civil society, the traditional rulers, the religious leaders, to be able to move those amendments forward.
Elect John Dramani Mahama. So Clara is going to take us through explaining. She's the chairperson of this committee that just submitted its report to the president, who has assured that he's going to forward to President Mahama and also make his own notes to him, and look forward to a broader consultative process to conclude on it. But before Clara does that, the Honorable Osei Che Mensah Bonsu joins us. Thanks very much for making time to join us, sir.
Thank you for having me once again.
Right. So he had executive oversight of this process, the Constitution Review Consultative Committee. But before Clara does the presentation and then he tells us why this is important in the first place, that he committed his ministry to, let's hear him on this Recollation and collation brouhaha, briefly.
Well, thank you, Samson. I wouldn't want to swim against the tide. The Supreme Court has come out with their ruling on the matter as to the way forward for us. Whether or not you agree or don't agree, you must tolerate it and live with it. That's where we are, and that is the essence of the rule of law. I would think that what determination that they've made for us as a country provides us with some headway. The collation and recollation of the votes before a final determination is made by the Electoral Commission. I've heard people make comments about that, and I've lived with this. In 2020, my own constituency, the EC was about doing the collation. I had indicated to them that I was doing my own collation. I will start. And in fact, they told me that we're going to start at 9. I got there at 9:15, and they had started. And in the night, and done about 50% of it. So it was a bit of a tussle between me and the EC officers. We began from afresh, subsequent to what I had indicated, that I was strongly against what they had done. And so we began afresh. So they had done the calculation of the arithmetic of it up to about 50%. Because at the time we had not had all the pink sheets delivered to both us as political parties and even the EC themselves. And then what they had done, and as a young man, I was quite close to him, the EC officer. They had done the calculation of the figures. When we started afresh, where they had got into, then I got to know that when we got there, we got to know that something funny had happened. That I had been shortchanged by about 3,500. And it had been credited to my opponent. Same thing had happened to Akufo-Addo and President Mahama, who was at the time contesting. Was it deliberate? Or was it not? I mean, let's face it. As for additions, we can get it wrong.
That's right.
So perhaps it wasn't deliberate, but perhaps it was also deliberate. And I think that it was deliberate because when we were still waiting and the man excused us, said he wanted to use the washroom, 15 minutes he wasn't coming and then we needed to continue. We went there and found him. He was sitting on the ground and he was sobbing profusely.
The EC returning officer?
I don't want to mention his name. And I knew the political leaning of that person. And yet, because we had been together for quite a while, I was taking care of the guy's school fees at university. And yet, that's what happened. As to whether it was deliberate or not, I cannot tell. But the fact that I caught him and he was sobbing tells me something. So these are matters that, I mean, human as we are, I think we need to find a way about them. But as I've said, the Supreme Court have made a determination.
Right.
Let whatever ought to be done before the closure. All that we need to know is the truth. That the truth is finally established. Who won? One person may win, certainly, but it must be done and be done rightly. I do know, for instance, that Obuasi East, at the very outside, was part of it.
That's right.
The guy had won by a very narrow margin, I knew. I had brought the pink sheets to us. He had won by 22. When they did the recollation, the number came down to 19. But he has still won. Why would anybody say that we will not allow the recollation to happen? Why? And then people say that, oh, let's go and mass up and prevent them from doing whatever. Is it necessary? Or perhaps has the time come for us to resort to electronic voting? If we're doing this, all these directing people to go and mass up at some places will not even be necessary anyway.
All right.
But we need to improve on our circumstances.
So we keep to the resolution and the path as provided by the Supreme Court.
Absolutely.
That's what he's saying. And for those who have the fears that, well, if you allow the declaration to stand, one person will be sworn in and the other person who will challenge the election, it may take them forever or the entire life of the parliament before they may be declared a winner. That is not going to happen this time because for a period now, these cases are going to be heard by dedicated courts. They hear only these cases and no other cases, and they do it on a daily basis, and the cases are supposed to be dispensed with dispatch. So those fears should be done away with.
On Saturdays.
Yes, Saturdays and holidays.
The Chief Justice intended to bring a constitutional instrument. He couldn't bring it because of what was happening in Parliament.
That's right.
And that is one of the things that we should be regretting. That Parliament, by their conduct, did not enable the Chief Justice to submit that constitutional instrument. You remember at the bar conference?
Yes, she assured that was going to happen.
That it was going to happen. And yet because of the raucous development...
And that constitutional instrument is intended to abridge the time for hearing parliamentary election petitions.
Yes.
Where the turnaround time will not be more than 3 months. Okay, so now let's go to Clara, the chairperson of the Constitutional Review Consultative Committee, and get to understand what it is that they have done.
Okay. Thank you very much. So I'm going to be as brief as I can. What I seek to do in this presentation is 4 things. We'll give a very brief historical background. an introduction of the committee, then a little bit about the process, the strategy, approach, and methodology of the committee, and then some of the key recommendations. We can't say all of them, but we'll give some key highlights and then our recommendation on the way forward. So on the brief historical background, as we all already know, we had our independence in 1956, but it was not until 1960 that we became a republic. So we had our first Republican Constitution in 1960, but it lasted just 6 years. So from 60 to 66, that first republic ended. It means we had a coup d'etat. And then again, we went back, we had the second Republican Constitution in 1969. We came back to democracy. That one lasted just 3 years. So from 69 to 72, just about 3 years. And then, of course, that democratic dispensation was disturbed again. So we had another coup d'etat, and then we eventually had a third republic. So in the third republic, that was 1979. It is the shortest period in our history. It's less than 3 years. It is less than 3 years. Before eventually we went for quite a while before we eventually went back to democratic rule through the 1992 Constitution.
But you meant to say that the 1979 one lasted a little over a year, not 3 years.
I said it was shorter than 3 years. Okay, yes.
Lasted more than 2 years.
Yes,
Okay.
it was shorter than 3 years.
Okay.
It was shorter than 3 years, yes. So now and the fourth Republican Constitution is secured by the 1992 Constitution. So we've since had the fourth Republic, which came into force in 1993, and it has continued for over 3 decades. It has seen now, if we add these elections, 9 democratically elected presidents and 9 parliaments. It has also witnessed a transfer of smooth and peaceful transfer of power from one political party to another political party. This constitution has survived the passing of a sitting president, and then power transited smoothly again. Again, this constitution has witnessed, for the first time, where we had a speaker who is not a member of the government. And the republic survived it. And then, so in short, the point I am trying to make is that we cannot run away from the fact that the 1992 Constitution has been our most resilient constitution.
Yeah.
So there is certainly something about it.
Yes.
And one of the things about that constitution is the fact that it was the constitution that was passed at a referendum, adult suffrage, and it had over 92% voting yes. So there is something in a document like that that has survived and continues to survive different scenarios, different circumstances, and it is still carrying us through. That is not to say that it is perfect. As we just heard the president-elect say, we've practiced this for some time, so we also see aspects that are in need of improvement. So there is a basis for proposed amendments. And these bases include the fact that we need improvements in certain aspects of the Constitution, and we also want to deepen democracy and the democratic principles that we practice. So in short, we had the minister responsible for parliamentary affairs who put together, who wrote to certain institutions to nominate persons onto a committee for purposes of taking another look at the Constitution, and also the CRC work that was done. As we know, the major work since the 1992 Constitution with respect to review of the Constitution was the CRC's report, the work that through Professor J.E.A. Mills, the Constitution Review Commission is the first major work step taken towards a review of the Constitution. But we all know that it did not end up in an amendment. And that report was in 2011. So the process was revived again because we have to agree, as you heard the president-elect as well, that time has passed. Things have changed. So we needed to revisit those recommendations and also see what the way forward in terms of amending the Constitution. So the minister responsible for parliamentary affairs put together institutions, and these institutions nominated their own persons. So they nominated their own representatives onto the Constitution. The effect was that we had a very diverse, inclusive, and independent committee. The interesting thing was that when the committee eventually assembled, we realized that we had someone from the consultative assembly, the consultative assembly that produced the 1992 Constitution, and certain people who had worked with the CRC as well, then senior citizens as well, and then of course young people as well. So the mandate of the committee, or the terms of reference for the committee, was one to review the Constitution Review Commission's report of 2011. After this report, there were a lot of stakeholder submissions, over 60 of them. Over 65 stakeholders made proposals with respect to amendment of the Constitution. So we also reviewed those stakeholder submissions. Submissions were also made on various constitutional review platforms. And then, of course, part of the TOR included to make recommendations to the Ministry of Parliamentary Affairs and its partners and collaborators, and then submit a report on suggestions of firm resolve for a review of the Constitution. Now, what strategy did the committee adopt? First was that the committee decided that we will not redo or undo what the CRC did, but rather we would build on what the CRC did and then include changes that may have occurred since the 12 years ago when the CRC report was authored. So to do this, the committee adopts the CRC recommendations where same is not overtaken by events, harmonizes the CRC report with the government white paper, and as well as the over 65 submissions received, and then consider whether there are more efficient ways to achieve the same objective. And then, of course, once we consider all of this, we then made recommendations. Now, the approach that the committee adopted was a clause-by-clause consideration of the entire Constitution, vis-a-vis what I just talked about, the CRC report, the stakeholder submissions that I just talked about. So we go clause by clause, and in measuring the clause by clause, we had certain underpinning values. And these underpinning values were liberty, equality of opportunity, prosperity, inclusion, respect for diversity, freedom and justice, accountability, rule of law, protection and preservation of human rights, unity of our nation, stability of our nation, sovereignty of the people of Ghana, respect for our cultural heritage, friendship and peace with all peoples of the world, and then other democratic values. So in terms of the recommendations that we make, these are the underpinning values. We also took the approach that constitutions are broad frameworks rather than manuals. This is because there were a lot of stakeholder submissions that wanted certain details included in constitution, but that's not the nature of constitutions. So we had to bear in mind the nature of constitutions when we were making the recommendation. But the entire objective at the end of the day was to ensure that this report reflects who we are as a people, so it reflects a certain Ghanaian identity, where we are 12 years on since the CRC report, where we want to be in our democratic journey, and then the aim or the objective was to recommend a constitutional framework that puts us in a position to pursue the Ghanaian aspiration for democracy. The process, briefly on the process that we undertook, it was a comparative process, so there were a lot of meetings, physical, residential, virtual, a lot of analysis. We received briefs, analyzed other reports, held validation workshops with several entities, national, international, some included CSOs, traditional, ordinary citizens, retired Superior Court judges, current parliamentarians, retired parliamentarians, private citizens, business people. We participated in validation workshops with these groups of people so that at least the recommendations that we make, they could give us feedback and their perspectives on it. The committee also had certain guiding principles, and these principles were: one, does it belong in the Constitution or it belongs in an act, regulation, political party constitution, or other document? Then two, people made suggestions. We look at the suggestion and we look at the current provision. Does the current provision achieve the effect? If the current provision achieves the effect, there is no reason to disturb the current provision. We leave it as it is. And then number three, for the suggestions that were made, we consider, is it consistent with the clear values of the Constitution? If it is not consistent with the clear values of the Constitution, there is no need to take it on board then, or add it, or it should be modified to reflect the values of the Constitution. Now, what was the scope of the committee? We limited ourselves to the 1992 Constitution in terms of the recommendations. So that means that we were not making recommendations for other pieces of legislation like Acts of Parliament or CIs or other administrative requirements. So this is in brief, this is the procedure or the process that we use to come out with the recommendations that we are now going to look at. So now let's look at a sample of the key recommendations. The first one is the procedure for amendment. We are aware that the CRC recommendation was to group them in the two, the entrenched and then the not entrenched, but all of them would be in one bill. What it means is that if you were going to have a total of 30 entrenched clauses that were going for a referendum, you vote yes or no for the 30. Now, the committee took the view that if you do this, you are more or less railroading, considering that the 1992 Constitution itself was voted for at a referendum. So if the people said that for these particular provisions, if you want to change them, come back to us, we must do likewise. So the recommendation was that after at the end of the day, we consider which proposed amendments fall within entrenched and non-entrenched provisions, and then pursue them accordingly. So for the ones that fall within entrenched provisions and so require a referendum, the committee's recommendation is that the proposed amendment must be grouped under the applicable subject matter and relevant consequential amendments and pursued separately in separate individual bills. In short, if you want to look at a particular subject matter, look at that subject matter, allow people to vote separately whether they want it or not. Let's take an example is just the aborted referendum, which was for the election of MMNDCs. We realized that whilst people wanted to elect their MMDCs, they didn't want to elect them on partisan lines. So you give people a choice if they understand it and they decide that this is what they want. So the proposal is that group them separately and then allow each proposed bill to be voted for. So the persons can vote separately for each bill. If they like this, they vote yes. If they don't like this one, they vote no. Rather than put all of them together where they may like 5 and then they don't like 5. If you put the 10 together and they're supposed to vote, then what are they supposed to vote for? Yes or no? Because they like 5, but they don't like the other 5. The committee's view is that this gives the people of Ghana the opportunity to reflect on the effect of each amendment and decide whether or not they want that specific amendment. The benefits would be a real opportunity for individual reflection and then decision on each bill. For the ones that fall within non-entrenched provisions, it's much easier, as we know. So this one, since it is Parliament that would be dealing with that, Parliament can decide how they want to proceed with it, whether they want to proceed just like the ones for referendum, or they want to proceed differently. A third recommendation was, of course, what the CRC recommended, which is do all of them in one bullet bill. But our recommendation is, at the end of the day, as we noted, we go for the popular consensus, let the people decide which they think really works for them. So now, if you are going by the first one, which we talked about doing separate bills, you must have a priority list for consideration. So what the committee also did was to seek to look at what a priority list would be, because you would need to decide which of the provisions you want to pursue at what time. So the recommended priority list includes one that we look at the caps, to cap the appointment of ministers of state, and then also, which of course would go with capping the constituencies in Ghana. Also look at the appointment of ministers from parliament. Of course, that the president must pay tax, election of MMDCs, and then emoluments and conditions of service of selected government officials. That is the Article 71 holders. We also, the sixth is to look at appointments of independent constitutional bodies, such as the EC, NCCE, SHRAJ, and then the provisions on the declaration of assets, the National Development Planning Commission, functions of the Commission on Human Rights and Administrative Justice, and then fundamental human rights. So these were the priority lists that we looked at. Now, considering, of course, so we are going to do the selected recommendations. As I noted, we can't talk about everything within this.
You have a priority list on which you have John Mahama proposing that he would also want to scrap ex gratia.
Yes.
Interesting.
Exactly.
Let's go on.
Exactly. So we give the priority list. The president-elect can say that this is the one I want to prioritize. And then take a look at. So let's look at the key recommendations that we make. Now, so in this, we are putting the two key reports side by side so that we see where the changes are. If you take the issue about appointment of ministers, which is dealt with in Article 78(2). Now, if you look at the CRC recommended that we should leave it open for the president to appoint, which means that the president can appoint as many as the president wants. Now, the CRC has taken a different view, in the sense that the CRCC says that, no, let's not leave it open to the president to appoint as many as the president wants. Let's cap it. So the proposal that the CRCC gave, as Samson noted earlier on, was that the president should not appoint more than 25. But when we went for the stakeholder engagement, which included the two main political parties and more, all other political parties, they all said that they will not agree to the 25. But they would be willing to reach a consensus of 55. So they proposed a consensus. They agreed in principle that let's cap the president's power to appoint the number of ministers. But they disagreed with us on the number. We are asking 25. We say 25 is fine. They are asking for a consensus of 55. But they agree to the cap. Now, secondly, and
I remember Samokujeto.
Yes.
The Venerable Samokujeto insisting that they should also not come from parliament.
Yes, we are coming to that one too.
All right, go ahead.
Yes. So now, if you look at the number of MPs, for example, the CRCC did not recommend a cap. Again, the CRC did not recommend a cap, but the CRCC recommends a cap. We are saying that let's not just cap the president's power of appointing ministers. Let's also cap the number of parliamentarians. Let's cap parliament. So we proposed a cap of 277. Now, let me give a reason. The reason is that we already have 276. Now, we cannot, if we want to cap parliament, the committee took the view that we cannot say reduce the number of parliamentarians. Because if you say reduce the number of parliamentarians, we can all guess what will happen. We are all in this country. No political party is going to agree for the constituencies in its stronghold to be reduced. On the other hand, each political party will have very good reasons why the constituencies in its opponent's stronghold must be the ones that must be reduced. So we took the view that it would bring unnecessary acrimony. So let's maintain what we have, but an odd number is ideal. So we can just add 1 to make it an odd number. So it is the reason behind the 277 that the CRC recommends. Now, another contentious issue as a country that we've been dealing with is whether or not members of parliament should also serve as ministers. We know that as under the current constitutional dispensation, the requirement is that majority of ministers should come from parliament. So necessarily, parliamentarians will serve as ministers. We have seen how it has worked. Has it worked well for us? Now, if you look at the CRC, what the CRC recommended was that let's leave the president a free hand to decide whether they want to appoint from parliament or they want to appoint from outside parliament. So what it means is that the president can decide to appoint all from parliament or none from parliament. The CRCC says that no, we agree that we should give the president a free hand to appoint from within or without parliament. However, if you are a member of parliament and you are appointed, then you must vacate your seat. So you make a decision whether you want to be an MP, whether you want to be a legislator, or you want to be part of the executive, but no mixing of the two. We were not unaware of the history that led to this provision, which was that in the Third Republic, the president's budget was not approved. The consideration was then that if you make some of the ministers from parliament, it would make things easier. Our point is we have practiced it. Now, even with the benefit of hindsight, what is wrong with a budget not being passed? Parliament is supposed to serve as a check on the executive. So what is so wrong about a budget failing to pass if there is good reason for it? And for that reason, we have to appoint ministers from parliament. In any case, we've worked with it. And a lot of parliamentarians agree, or there are some parliamentarians who agree that left alone, they are not interested in the work of parliament. The only reason they contest parliamentary seat is because it is a means to getting ministerial appointment.
Right.
In which case, the work of parliament is going to suffer. So we make the recommendation that make a clean break. You either want to be an MP or you want to serve in the executive. If you are an MP and the president decides to appoint you, it is up to you to decide whether you want to accept the appointment. If you accept it, resign.
I'll need us to fast track a bit, and you conclude on this, and then we go to the steps forward.
Okay.
Right.
So so of course, then the election of the MMDCs, we recommend that it should be by election, but on non-partisan basis. With respect to the emoluments of Article 71, we propose that just have a predetermined formula, and then after that, the Fair Wages and Salaries Commission can manage that formula rather than keep on setting up committees. So they manage like they do for everyone else. And then let me talk about this one too. We also take the view that with respect to appointment of independent constitutional bodies, that it should be by open competition. So open it up, advertise the position, have rules and regulations, pass a legislative instrument, let people apply. Then at least the EC can rest from all the suspicions from the various political device and all of that. We also recommend that when it comes to declaration of assets, don't just declare, it has to be verified and a certificate of verification issued. Now, of course, we have a recommendation on the quorum of parliament as well. So let me go straight to the next step, right?
Right.
So this is a sample of the recommendations that we have. And with respect to our next steps, we are committed to ensuring that the voices of the Ghanaian citizens are central to the constitutional review. We take the view that these are recommendations or suggestions to the people. It is important to have the people agree or disagree or modify whichever way suits them. So what both the president and the president-elect have talked about, we do need broad stakeholder engagements across the country to get the citizens involved and then to reach a consensus on the way forward, what kind of democracy we want, what recommendations we want to go by, and then pursue accordingly. So in short, these are the next steps that we recommend, that it shouldn't just be taken hook, line, and sinker. It should be presented to the people for their view on it. Thank you very much.
Thank you. Thank you very much, Clara. And I'll come straight to Osei Mensah-Bonsu, who has oversight over this, and his ministry propelled all of this. But I also have not forgotten that sometime in 2018, actually the Attorney General, Gloria Akufo, had set up a committee The Attorney General, Gloria Kufuor, has set up a committee that she called the Constitution Amendment Review Committee. I remember that committee had Godfrey Dame, Joseph Kwenka, Obi Amwa, you had Anthony Akoto-Ampao of blessed memory, Professor Henry Kwesi Prempeh, Henry Taki, Chief State Attorney, you had Heidi Boache, you had several other people who were to do a number of things, review the Constitution, among other things, the proposed amendments, how they were to be gone about. That was in 2018. Then you come in which year, and decide that this is how we have to go. Why is this that important, that it doesn't leave any government?
Thank you very much. Let me first express my deepest appreciation to Madam Clara T. Keseti for what profound work that the committee has done in trying to align and synchronize the various reports that they work with. A huge load that they put into one basket and endeavor to sift, and they produce a very wonderful document for us. As we said, we've lived with this constitution for the past few years. I've gotten to know the various deficits in the application of the constitution. So to some of us, the practitioners, we came to a conclusion that we needed to offer some twists and turns at various provisions. So I remember early 2018, I raised this matter, and with Gloria, who was the Attorney General, and she indicated to me that she agrees and that something ought to be done. It was really ensuing from what we had started doing at the ministry with the expanded leadership at the time. And we had come to some conclusion that we needed, as a way forward, to revisit what had been done by the committee that was set up by Professor Mills. So that's how the whole endeavor got off the ground by the then Attorney General. But independent of her own effort, as I said, we had already begun our own at the Ministry of Parliamentary Affairs. Unfortunately, along the line, her endeavor fizzled out, and then ours then grew. And then together with my colleagues and compatriots, the Honorable Fuseni Inusa, the Honorable Ben Abdullah, who at the time, the two of them were with the Constitutional, Legal and Parliamentary Affairs Committee. And that's why I so much leaned on them to join me to get this onto the track.
Gloria Kufuor's committee was looking to do, if you like, piecemeal implementation.
Absolutely.
So they took one by one and proposed how to go about them.
That was the difference between what we proposed to do and what they set out to do. And so the combination of events is what has been related to by Madam here. And I think she's not even related to all the aspects. For instance, dealing with the executive. I mean, we all acknowledge that the powers and responsibilities vested in the president, too huge, too many. How do you cure that? Is it to submit some of the appointments that the president makes to Parliament for approval so that it becomes a shared responsibility? It's one matter that is outstanding, and we need to make progress, which is already related to the appointment of cabinet ministers to come from outside, the number, the presidential travels, whether once the president travels outside Ghana, he ceases to be a president such that the vice president should take over. And in the absence of the vice president, the speaker also takes over. These are matters that we need to deal with.
She was on this same platform. She was on this same platform. Sorry about this brief interruption. With Anthony Forsing Jr., former president of the Ghana Bar Association, who was also the youngest in the Consultative Assembly that made the 1992 Constitution. And when they suggested a capping of the ministers to 25, there was such popular support for it. Then you go for the validation process, and I saw all the senior statesmen Okujeto, I saw Setepe, the rest of them, Minister Fuseni himself were all there. And you agree now that it should come to 55 rather than 25.
The reason was that when they suggested 25, it didn't include the regional ministers.
Right.
It didn't include the regional ministers. At the time they had 10, now we had 16. So if you take 16 from the 25, are you suggesting that we can only have 9 ministers?
Okay.
So it didn't include the regional ministers. Now we have regional ministers. And we also recognize that, yes, there are certain ministries that one could do without having deputy ministers. There are some that necessarily require deputy ministers. For instance, a ministry like finance and economic planning. If you have a minister for the ministry who is strong on finance, you require somebody to assist him whose strength will be on economic planning. We are now talking about realigning ministries. A ministry of transportation, for instance, would superintend over roads and highways, aviation, ports and harbors, railways, and such. You're not saying that one person can superintend over all these. So you need an engineer perhaps, who will be in charge of maybe roads and railways, and the other one for aviation and ports and harbors. So there, and then mines and energy, if the ministry should remain like that. The two are different, natural resources. So those configurations would have to be worked out.
Okay.
So I'm just saying that there are some that require deputy ministers.
So you
others
proceed on your
Yes.
substantive point, because
Now,
their proposal was that you scrap deputy ministers and all of these things.
No.
So
I
you
think
make a point
we have agreed. We
and
have come to some
again,
consensus.
you agree that eventually this will be for broader national consultation.
Absolutely.
So the people's views
would matter.
What will matter.
Would matter.
All right.
In fact, we were intending to do after this one, the next step for us was to have some cross-sectional representation to interrogate the issues contained in the report. After which, perhaps we will lead ourselves to maybe a consultative assembly or whatever. Because, as we said, this constitution was validated by the general populace.
That's right.
So ultimately, it will have to go back to them. And that is what maybe, sometimes we disagreed on the processes and procedures. Some of us do think that we can boss everything together at the consultative assembly level to have a new document, and then we shall have just one referendum on that. If the people approve of it, it then supplants what constitution, and it will cut down the cost.
Right.
But that's something left.
We're talking about the importance of this
Yes.
and why
Yes.
no government appears to leave the subject.
Yes.
Before I came in with my question. So
Yes.
proceed on your substantive.
Yes, and I was talking about, for instance, the executive. Have you looked at the tenure of office of the president under Article 66? It does 4 years, and that's it. Whereas, and that is an entrenched provision. But under Article 113, where there is, the country is involved in war, for instance, Parliament can extend its life by 4 years. But the president, who is supposed to be the commander-in-chief of the armed forces, who's supposed to lead the effort in the war situation, will have to exit. And there will not be any president or vice president, but there will be a parliament. There's a clear vacuum. So how do you cure that mischief? So it was something that also engaged the attention of the NDPC. Madam spoke eloquently about that. The Constitution requires governments to continue with the programs and projects executed by exiting administrations. We're not doing that as much because a party comes with its own manifesto and they think that let's restrict ourselves to this manifesto. Meanwhile, a road is being constructed. Another government comes, he sees that, oh, this road is not my priority. He leaves it. The road construction has gotten to some level. It's abandoned. 2, 3 years, 4 years, we come back. And the nation loses so much.
Because you have to start all over again.
Because you have to start all over again. And it's all because the NDPC, which is so to define a long-term development plan for us, it's not accorded the pride of place that it should. It's not accorded the pride of place because of the composition of the NDPC itself. It comes out as a very politically tainted, body. Today, the the NDPC is made up of 47 members. The 47 members, about 32 are ministers and deputy ministers of the NPP administration. They've come up with a brilliant document. Do you think the NDC will have a buy-in? They will come and they will throw it somewhere and constitute their own NDPC. So we keep moving forwards and backwards and not making any progress. You've spoken about what to do with the speakers, the parliament. Ghana's parliament is only 1 out of 9 parliaments in the world whose speakers are not members of parliament. Is it helping us? Or perhaps it's retarding our progress? If the speakers are members of parliament, there is a kind of peer review system. And, you know, Madam was even alluding to the number of 276 as against 277. Now, if the speaker is not to be a member of parliament, then we require the 277. If the speaker is a member of parliament, which some of us believe he must be, because if you have a speaker who is a member of parliament, his attention is on parliament, how to develop parliament. We have had situations where speakers come, they are not looking to develop parliament, but they are self-seekers. Let's be blunt with ourselves. It cannot continue. If you have a member of parliament as a speaker who knows that his colleagues know him, he will submit himself to parliament. So that is how to grow parliament and having situations where resources that are for parliament will be utilized by parliament, the committees of parliament, which are the vehicles for advancing the cause of parliament. Parliament's committees need money to work, and they don't have them. I'm not talking about this parliament. It's been with us. They don't have money to do that because the speakers have a way of dealing with the clerks. Oh, let's sequester this amount for me. We want to do this, we want to do that, which may not be the priority of parliament. If the speaker is a member of parliament, we'll look at what is required to be done for parliament. The Council of State. Samson, if you look at the construct of the Constitution very well, with respect to, first of all, the number, it provides for, when we had 10 regions, the president was required to appoint from these 10 regions. Now it's 16. From the 10, the president appointed 11 members, additional. Now they represented all of them came from the regions, the 10 regions. Today we have 16 regions. Can we have 10? The Council of State, or 17. The Council of State, if you look at what they are required to do, you look at Article 90, they deal with bills. You look at Article 91, other matters. The Council of State, by the construct of the Constitution, really is supposed to be the second chamber. Have they been living up to that billing? They haven't. How do we make them proactive and focus on their prime responsibilities? It's something that we should be looking at. We've spoken about capping the number of seats in Parliament. The immunity of members of Parliament is something that we have been talking about. Article 117, that they are immune from service, from the processes from the courts. 117, 118. How do you cure that? So these are matters that, and then finally, you notice that whereas Parliament has the function to approve of supplementary budgets where maybe in a particular year funds appropriated for expenditure are proved to be insufficient, or perhaps maybe there's a windfall and we have additional resources we need to spend, where a supplementary budget is placed before Parliament, Parliament can and must approve of the supplementary budget. If you look at the present construct of this Constitution, the main budget, it comes to Parliament, and the Constitution says that it's only for the information of Parliament. It doesn't need the approval of Parliament. How do we address it?
Right.
So there are matters of substance. The judiciary, we need to, purge the Constitution of the position of public tribunals and so on. As for the capping of the number of Supreme Court justices, I know you quarrel with me. But the chairperson would also quarrel with me when I raise these matters. But there are matters that ultimately the general public...
we had 12 institutions, the University of Ghana School of Law.
Yes.
Clara was nominated from that university, and she became the chairperson by their own voting of the National Commission on Civic Education, the SHRAJ, You have the Africa Center for Economic Transformation,
Yes.
Professor John Asafoye. You had National Media Commission, NMC. You had the Judiciary, represented by Justice Yoni Kolendi. You had the Audit Service, Parliamentary Service, Nana Tewia Ochi. Ghana Bar Association, Anthony Forsing, the Ministry of Justice and Attorney General, Alfred Yeboah, the National Development Planning Commission, the Ministry of Parliamentary Affairs. This work...
The current president and the former presidents as well.
Okay.
President Kufuor himself was with us.
Okay.
And from former President Mahama, now President-elect, his office also brought submissions to us. So the whole
I was
thing
only
is
referring to the
fertilized.
membership of the consultative committee.
Right.
So you submitted your report to the president on Monday.
Right.
And the president was very clear about it that there were aspects that he too didn't seem to agree with you even before he reads it.
Yes.
But he will make his copious note.
Right.
He was very particular about that and insisted that he would pass it on to John Mahama and propose that there ought to be broader national consultation. What's the point? We are going back and forth. Some see, what's this? With this CRC. And this work is hinged on CRC's work.
Yes. No, I think we are not talking at cross purposes. What we had intended to do after this, where the next step for us from the ministry was then to open it up for a cross-sectional interrogation. I'm talking about cross-sectional representation of the people of this country to interrogate what we come up with. And after that, in fact, we're going to elevate it to a national discourse. Perhaps sustain it for about 1 month, let the people talk to them. And then from that, we have this forum, which was going to last for a while, maybe about 2 weeks, and various issues, various aspects. We're talking about the executive, we're talking about legislature, we're talking about the judiciary, independent governance institutions, and so on. All of them were going to be interrogated by them, from which we thought would be born a consultative assembly or a constituent assembly, however it's so described. So what the president was talking about is about the same thing. And you remember that the president-elect, John Dramani Mahama, former President John Dramani Mahama, has already even spoken to it. He says he's heard that we are doing this. He will submit it to public validation. It's about the same thing. So I think we are
reference there was to the CRC's work, which was
he mentioned
Professor Mills's work.
No. He mentioned when Alan Chemate went to see him.
Right.
But he mentioned especially what we have been doing. And I remember I saw him and I heard him mention that he knows that Chairman Sabunsu is also using a committee to also interrogate this matter. We need to submit the report to, and in fact, he and I had already earlier on had some discussion about what we had been doing. So I think that we are heading towards the same path, and how to bring illumination to it and how to bring it to a closure. But I think, and I agree with him, that further to what we have done, we must have a cross-sectional interrogation of the issues. I never foisted my own position on the committee.
Your position is known, and we have debated it on this particular platform on special edition with constitutional theorists like Mame Mensah Bonsu and the rest of them.
Right.
And many people loved your positions, including your advocacy for the Westminster system.
Yes.
But it does look like even this new proposition at the final work, it's more than what you had expected. Your number of ministers, you were looking for a number of what, less than 40 or so?
No, I was proposing that, let me say that, you know, our presidential candidate mentioned the figure 60. And I think that I was instrumental in determining the figure 60. President Mahama has mentioned,
Your presidential candidate talks about 50.
50. I was very instrumental in that. President Mahama talks about 60, and I think it's not too much of a departure. But before then, even before this, the committee had come to that determination that no, 55 is good.
Okay.
So I think
hold
that
your thoughts
we are
there.
about
Hold your thoughts there. I'll take a quick break. I'll return, and remember that. Thank you very much for your patience, Honorable Ikoyo too, and also Oliver Barker, former war, who had a lot of work to do with the CRC. And Yunus Hafsini is right here in the studio, and the chairperson of the Constitution Review Consultative Committee under this administration, Clara Berry Kasati, is also here. There are people who are excited about what you guys are doing, but there are some who also feel that they are looking for a lot more drastic things that today they haven't heard as they heard earlier. It was work in progress. We'll take a quick break. We'll be right back. You're welcome back. This is Newsfile. It's your most authoritative news analysis platform. And we just heard the Honorable Osei Mensah Bonsu. There's a momentum for constitutional amendments. Both president and president-elect, everyone, it's been on their lips. So, John Mahama has also demonstrated commitments or been speaking about it. Let's go to Oliver Bakavomowo. He was part of the Constitution Review Commission in 2010, which submitted their report a year after. And there was a court process that also stalled that for a while. Oliver says that Mahama got, this is a comment he made, it went viral. He said Mahama got 56% of the popular vote. That was much earlier. 14 out of 16 regions, 68% of the military vote, and 80% of the police vote. Over 2/3 majority in parliament, still possible. A president who is a one-term president and so has no re-election concerns. A person who has presidential experience and so can hit the ground running from day one. Listen, it took 32 years, 8 regular election cycles, and 2 runoff elections for us to get here. We may likely never be here again. So hear me when I say, this is a mandate for constitutional reform. This is a mandate for probity and accountability. Yeah. If I ever saw one, a mandate to build a legacy no one has ever been able to build, apart from Nkrumah. And he said a few other things. Oliver, now the president is coming in to get sort of the process being cooked for him, correct?
There's no question about it. I mean, I think that, particularly on the question of constitutional reform, that we have been on this course for at least since 2008. That there's so much that has been produced within the last few years, 16 years perhaps, that we can say that we have a broad view of the issues on which we have consensus and the issues of which we are still divided. In terms of the constituencies that are mobilized around this issue, we know they are diverse, we know where the positions are, and even those whose positions were still evolving have now gotten to a point of constitutional clarity on which a broad consensus can be formed. Our view is that what is left now is how we can all rally around the incoming president to be able to achieve this. That is important. Now, of course, I'm hearing the Honorable Chairman Sabunsu on the question of revalidating and conversation. I'm a Democrat at heart, and I understand the core. The concern I think a lot of people have had over the years is whether or not it becomes another way of filibustering the process. Because every start and stop, we come again with a reconversation. And the risk is that it never gets done. But we, persons within civil society, some of the political actors as well, ought to be able to consolidate ourselves and build the pressure from ordinary people as well to ensure that this process goes through. There are still certain questions that are still unclear. And I am agreed with the position that says, if we are bundling up all this issue and presenting to the voter, then we are not necessarily being fair because the Dem cannot have an opinion on the individual amendments. I don't necessarily think that the problem is solved by debundling them, because if you put 60 amendment bills before an individual voter, it requires informing yourself over 60 different issues that are themselves complex. I'm also a bit suspicious also about amendments which are tweaking and not necessarily transformative. And I'll give an example that I often hear. This question of, for instance, I think Honorable Chairman mentioned about when the president travels and somebody is in office. It's a dead horse, in my opinion. We've gone to the Supreme Court several times on this issue. And at this point, it seems those of us who are on the side of, well, let's not swear another person in, I want to use the opportunity to get one in. If it's going to be a point which will draw us back, let's leave it. But there are key areas of how we deal with our democracy that we cannot ignore. In my view, and which I have not heard talked about, the big question for a democracy like ours is the fact that the power of constitutional initiative does not belong to the people. Meaning that only Parliament and the executive can commence conversations around constitutional reform. The people are left out of the process. If you go to Kenya, for instance, there's the power of the popular initiative, where citizens can mobilize themselves and get, say, 1 million votes to be able to put a question to constitutional referendum. I think that we need to be able to have a process by which we bring the people in and have an initiative to initiate conversations about constitutional reform. It's important. There's also different aspects. And we, for instance, on the 21st of January, Democracy Hub is organizing an event called The Case for a New Constitution, where we are going to be stating our constitutional priorities and also setting out a roadmap around which we're hoping that everybody can coalesce around. So there's ample evidence of things around which we can find ourselves. And it is important that the old divisions that have not allowed us to be able to mobilize ourselves concretely to ensure that this is delivered by the political class can be resolved. My hope is that conversation, those who are on the panel as well, will join us on the 21st of January, which is at the British Council starting from 5 p.m., and that we will then be able to develop together a roadmap for how we consolidate ourselves and move forward. But on that day, we're going to be unveiling a 15-point constitutional reform agenda. Even as we are stating the case that the new constitution is probably the way forward for us, we understand that not everybody is going to get everything that they want in this process, and that we have to be able to find consensus and also understand that we may win some and lose some, but the important thing is that there are certain things on the agenda that we must coalesce around to ensure the new president gets the support to be able to deliver.
So this program that you are having at the British Council, and you are going to lay out your proposals, don't you believe rather that it better fits into the time when perhaps President Mahama will constitute the process to validate the, Professor Fiajo report and also this Claraberry report?
So this is our view. Our view is that the process should not only be left to the executive's timetable or timeline, is that we ought to be galvanizing or creating the momentum that leads into that conversation. So we don't wait for when that happens, but that we start gearing up and start educating and start having conversations that will consolidate at that process at the time in which they do that. So critically now, remember, one of the things that we have done over the past is that we have consistently avoided getting into specific of what the constitutional reform agenda should entail. And we have said that we think that the most important thing is to get everybody around the table to rally the process forward. And so what we have done is be able to usher us into these conversations towards this point. Now, throughout this process, we have been consolidating what we think that consensus can be built around, and that's what we're going to be stating. There's nothing which would enrich the process the president-elect intends to put forward than broad consolidation of processing and also public enthusiasm for it. And that is what we are creating, public enthusiasm ahead of that process. Because our fear is that if we leave it to a timetable that is uncertain, we worry that it may not happen. So let us give him the full support by inviting conversation him and see that, as we say in Ghanaian parlance, our eyes are red for constitutional reform to happen.
Interesting. Let's go to ICO 2 now. I was coming to you about the question why the Constitution review question or debate doesn't appear to disappear from, the table. Why is that? But hold on briefly for me. I understand that some confusion has erupted at the Greater Accra Regional Coalition Center as the parties disagree over the number of polling stations to recollate in the outstanding Dome Kwabenya constituency. James Aveji, are you with us? Hello, James. So our man James Aveji is at the Recollation Center where the NDC and NPP can't seem to agree on how to proceed with the Domikwa Benya process. Please unmute your mic and do this very briefly for me. What's the problem?
Well, Samson, just some few minutes ago, there have been disagreements over the number of polling stations to consider in this recollation process. We know that leading to today, what we've been told consistently by the Electoral Commission is that there are 3 outstanding polling stations in the Domikwa coalition. And so just before the process began, the NPP parliamentary candidate, Eromal Kokwe Jr., raised some objections. According to him, in the dying hours of the coalition in the constituency, just before the chaos erupted, they were left with some 88 polling stations to be collated. And according to him, that the rest of the 88 was done all up to 85 when they, the NPP, were not present before that declaration took place at Domikwa Benya. And so he was insisting that the EC here recollate the rest of the 88 that was done in their absence. That brought all of the confusion with the parties charging at each other, disagreeing over the process, leading to some banging of table and all of that. But as we speak, that has been calm now. The NDC is insisting that only the 3 outstanding police stations are collated and declared. And so just a moment ago, you may see Dr. Srebo behind me. They went into a brief meeting and then he came back to inform the parties that what has been agreed on is that among the 3 outstanding polling stations, 1 result have been entered on a presidential pink sheet. And so the agreement is that that particular polling station is set aside. They collate the rest of the 2, and then whoever comes second, the result of the outstanding 3 will be added to his result. If that makes a difference in the final result, then they would have to go and do a rerun of the election in that particular polling station, which results have been entered on a presidential pink sheet. And so that's the agreement, and the process is expected to continue now.
All right, thank you very much. So, Oliver, my question, can you respond to that briefly?
If you don't mind,
why is the Constitution Amendment debate never dying?
I don't think it would even ever die, even if we have the Constitution Amendment done. One, but historically, let's go back to the beginning of the Constitution itself. Because even getting a new Constitution was very divisive and also politically contested. The nature in which that process evolved and the participants that were involved in the process was different. If you recall, the Ghana Bar Association had boycotted the process, even when we put in place the Constitution at the time. The MPP, for instance, at the very beginning, when the party came into being, was clear that it was going to ensure a process for constitutional reform, if not a new constitution, in that place, because he held the view at the time that that constitution was not advanced enough in terms of ensuring our democracy sustaining itself. There were debates about the indemnity provisions of the constitution and whether or not that creates a republic of a rule of law. So in many ways, as many times as we would have frustrations with the political class, it will generate constitutional demands. As many times as there will be friction between the various arms of government, it will generate constitutional demands. That will be the nature of how the republic evolves. It is one of the reasons why the Constitutional Review Commission looked at the Ireland example and recommended that we should have a standing commission that is consistently filtering these constitutional demands. And when it rates where we have critical mass of support, we put them on the table for referendum on different issues. So that is not going to stop, we must agree with.
A standing commission like the Law Review Commission?
Yes, a standing commission like the Law Review Commission, in that nature, that will be receiving amendments and then educating and seeing the level of which these proposals get a crescendo to be able to see whether we can submit them to referendum. So we must live with the idea that this is not a closed box. But if after 30 years, ideas have been generated that seek to improve the substance of our democracy, then we must ensure there's a process by which they are delivered.
All right.
The current system does not provide an opening for that process. And whether that is through the popular initiative or a standing commission, we must recognize the fact of constitutional amendments. Even the US Constitution has received several amendments, and there's consistent talk of new amendments as we go forward. That is the nature of the constitutional life of every republic.
Thank you. So the Honorable Aikoto is still with us. Thank you once again. Okay, so he's not on presently, I understand. If we establish contact with him, we'll continue with him as well. So, look, and I'll begin with Honorable Yusuf Seni on this point. The Democracy Hub, they say they are holding a policy conversation titled The Case for a New Constitution on the 21st of January 2025 at the British Council. Now, I was asking whether the best approach is not to rather wait when the president inaugurates the validation process for them to submit to that process. And Oliver says, no, it's never wrong anyway. Let's do it and let whatever we say feed into whatever gets done.
Yes, so it's never wrong. We build in consensus on the need to have our constitution looked at again. And so it's definitely not wrong. I mean, even the amendments that have been captured in Clara's report will have to go through some work, either by the incoming president or by parliament. And so the process is an ongoing process. What we all agree on is the universal creed that we, the people of this country, haven't lived with this constitution for 30 years, which constitution is not delivering the promise it made to us in the preamble to create an equality of opportunities and prosperity for all, largely because of the weaknesses of certain institutions in the governmental framework that we have enacted or put in place for ourselves. Think that there are some things that we can do as a people to ensure that the promise given to the people of Ghana in the 1992 Constitution is met. That's all that we are doing.
But there's that school that says that the problem is not really about the Constitution, and that it's bad people that are making a good Constitution bad.
Yeah, bad people make good constitutions bad. And they do that because the framework that will secure that bad people behave in a certain way is not provided. And that's why you are told that constitutions are just the bones. Okay? Now, we must make sure that the framework itself is such that it won't give bad people an opportunity to thrive. Okay? And then we can give you numerous examples. Numerous examples. For instance, how can we as a people have an institution of state, the Bank of Ghana, whose actions moves 1 million people into poverty? How can we have that? What checks do we put in place to ensure that that never happens? We have been in Parliament for so long that we know that by the principle of separation of powers, Parliament, whether minority or majority, have to hold government accountable. The executive brings a policy, which policy is being debated on the floor of the House. But a member of Parliament wishing to catch the eye of the executive, the president, will see nothing wrong with the policy, will hear nothing wrong with the policy, and will talk nothing about the policy. Is that what we want as a people? That is why we think that we must give vent, a meaning, to the principle of separation of powers.
For you, what is the place of the CRCC's work, the Claraberi report, in the whole project going forward? Because you have been from day one, the very first day that the ministry invited people, Professor Bochi, I remember I was there myself.
Yes.
So, you know, you were there, Haruna Idrisu, and the debate began about the fact that you can't do a process without recourse to the CRC's work. That's Professor Fiajo's work. You have been part of it from that very beginning to the end. what should be the place of this report going forward?
Your question has been answered by Clarity. We said that we don't need to reinvent anything. His Excellency John Dramani Mahama, President-elect, has also spoken about it. That we have been caught by time. The CRC report has been caught by time. There are many things that will have to be reinterpreted in the context of the times in which we are. Clarity's committee appreciated that fact and took the Fiajo's report and looked at it, which were the low-hanging fruits. You heard the talk about priorities. What can we achieve? We realize that the enormity of the tax, as spelled out by the Constitution Review Committee, is said that we cannot, if we mean to go by that alone, we might not be able to achieve our desired goals of amending the Constitution. What is it that we can tweak, amend in the Constitution that will still deliver to us the promise of the Constitution, but within the limited time that we have for ourselves? And that is why the Hair Committee went at length to identify what can be done and how it can be done. The Constitution Review Committee, the missus, was that they had lumped a lot of, and that was why the first committee,
Fiajo?
Sophia Akufu.
Okay, Gloria Akufu's
committee. That was what they came out with. They said, look, the committee that was set up, the Constitution Review Implementation Committee, suggested that we lump all the
56 draft amendment bills for the non-entrenched provisions.
Yeah.
And there were also 41 draft amendment bills for the entrenched provisions.
Now, they thought, no, if you did that and lump them, you will have problems. You will not give the people what democracies are known to give to the people: liberty, choice. What do they want? If you lump them, you rob them of that. That's log rolling, bringing them together as one.
And that argument has been long-standing. I remember one of the IDEG meetings.
Yes.
After the report was submitted, Chairman Sabons was there at that meeting, and the major concern they raised, I remember Professor
Kwashiga
and Atupare made a presentation.
Yes.
And this was the biggest issue. Whether you lump the amendments up, how are people going to vote? And Professor Kukwasa was also concerned about that as well.
Yeah, so that is why, attempts have been made to say that, look, when we are dealing with the entrenched provisions, we must give the people the power of choice, as known in democracies.
All right.
And that also brings into question, what do we do? Do we constitute the parliament, when it's reconvened, as a consultative assembly to look at all the provisions, come out with, because people, they're going to submit draft bills. Look at the draft bills before they go. We cannot assume that what the committee has done and what bills will be submitted to Parliament for the consideration of both the Speaker of Parliament and the Council of State will be the bills that were presented to the people to vote on. There will be processes.
Okay.
But let's say that the processes start when we all agree, including our leaders, the flag bearer, not flag bearer, President-elect, now agrees that we need to move this process forward.
He said that already.
How do we move? How do we move it forward? There would need to be a committee, just like the Constitution Review Implementation Committee. There will need to be a committee of that nature. And the committee of that nature will spell out how they intend to engage the people to build broad consensus. Mind you, we are trying to look at the framework of government,
right,
and it must concern everybody.
And that should be part of the legacy that President Mahama would have to leave. You remember in the last two election campaigns, he has been blamed by his opponents, the NPP, that he sat by and did nothing with the recommendations that were produced by the Professor Albert Fiajo committee. They did an extensive work, 1,000-page report. And I say that is the biggest socio-political data that this country has ever collected. And it was like it was going to waste. And the work was valued at about $6 million US dollars. I'll be right back. We have Aiko Otu now on the line. He will speak and then call them the initiators and the conveyors of the process up to the end. Will have the last word. We'll be right back. Welcome back. This is Newsfile. It's your most authoritative news analysis platform, and here on Newsfile, we put Ghana first. And our stellar guest, you've been listening and watching since 8 a.m., having Clara Berry Kaseti. She teaches the law at the University of Ghana. She's also on the board of the Center for Democratic Development, CDD. Oliver Bakavoma, World Constitutional Rights and Policy Strategy Advisor at the Democracy Hub. Inus Husseini, former MP, former Minister, and who was also on the Parliament's Parliamentary Affairs Committee, Legal and Parliamentary Affairs Committee of Parliament. Aiko Otu, former Attorney General and Minister of Justice, leading member of the MPP, Osei Mensah Bonsu, Rare, here on the show. MP Swame, immediate past majority leader, and he's the man with executive oversight of the CRCC's work. Now, let's go to Aiko Otu for his thoughts on the constitutional review process going forward. Thank you once again. So, do you think sincerely that if you agree that the constitutional amendment should happen, it will ever happen with the divisions we see? Because, as President Mahama said, and we all acknowledge, the entrenched provisions that are being sought to be amended, the executive is an entrenched provision, judiciary entrenched, parliament entrenched provisions. Amending the entrenched provision is so difficult. If you don't have both parties coming together in a consensus, it will never happen. Please unmute your mic.
Thank you very much. I believe that we have worked with this constitution for about 30 years. We've seen the flaws, we've seen the dangers in some of the provisions. Otherwise, I would say that it has served us well. And that if there is a compelling reason why we should have some amendment at this stage, I do not see why we should not have that political will to go through it. It is true that the entrenched clauses might require some referenda. I remember when we were going to deal with the regions also, we had to go through this process. The chair, Osei Mensah Bonsu, will remember all the work they did, and then eventually we went for the referendum. So I do not believe that the divisions should be said that it cannot work. If it is sold to the public and they appreciate what is at stake and why we should make certain amendments, I believe we would get through with it.
Mm. And when the president on Monday receiving the report says that this must never be done until and unless there is popular support for same, and that people is gone round for people to buy into it. How do you appreciate that has to be done? In what form should such a thing take?
You see, it seems to me that we haven't had the political will as a party to look at these constitutional amendments. Let me put on record that during the manifesto thing in 2016, I was the chairman of the governance sector. I raised this issue. I said, look, we started something time back, and we are looking at laws and governance in general. So I would wish that we look at it again. It didn't go down well with the then candidates who became president for 2 terms. And you see that for all the 2 terms, we haven't really looked at constitutional amendments again. Regrettably, although it was at the ministerial level that the former Attorney General, I think you spoke about Gloria Kufu and the rest, it ended up getting such a Mensah. Rather, his ministry to start working on it again. So we have not really, I mean, I'll say it as it is, we've not really shown that kind of political will. I don't know whether it was the MPP that, or the government that asked Osache Mensah to look at it and come out with what he did, or that he looked at his own experiences as a leader of parliament at the time, majority leader, and working with the constitution and the difficulties that he felt. So to me, I don't think there are any sharp divisions. I mean, that phase is gone. Let's now come to this new era and sell the idea to Ghanaians and let them understand why we should do it. As you have rightly pointed out, the Fiajo one went round. I did a lot of work. I remember I joined Nana Akufo-Addo and others to go and make a presentation before them, remembering seeing my friend Gabriel Puama sitting there as a commissioner and all that. We were there to make, so they've done extensive work already. This Clara Kasati one, they are telling us that they looked at those that have already been made and didn't want to reinvent the wheel, and so tweaked it for us. So I don't think we need that wide consultations once again, except that the things should rather go back to the people and let them decide whether they want these amendments, to be taken on board.
Right. So do you think that whatever happens, the NDC regime or administration incoming have a fine opportunity at least to take care of the non-entrenched provisions, because they will have the numbers in Parliament to do so? If there are problems with the entrenched provisions where you will need at least, is it 40% of people who can have a right to vote coming out, and 70% of that number voting for the amendment?
30% and 70%.
Well, I think that they've, on 2 occasions, I think 2016, 2020 or so, I've always had it as part of their manifesto that they went back on constitutional amendments. And the president-elect has made it clear that he would go ahead with it. So I will not be surprised, and with their majority in Parliament, 2/3, if they have the 2/3, they should be able to, get, with what we hear, even some of the independent candidates saying that they won't work with them, they should be able to make the changes that they intend to, because it is not only something that they talk about, but it is part of their manifesto. They've been saying that they want to do it. So we wish them well.
In tackling the entrenched provisions, actually, the Constitution's requirement is for at least 40% of the persons entitled to vote coming out to vote in a referendum, and at least 75%, not 70, 75% of those people voting in favor of the process, the bill to pass.
Yes.
Did I hear you suggest that there is a bit of some coalescing of, views, and therefore it is not difficult to get a consensus going forward?
You remember when we wanted that, I think Osache Mensah can correct me, when we wanted to amend the regions, it went through something of the sort, and we were able to get through for the people to vote for it. So
right.
It's all a matter of selling it to the people, letting them understand why certain provisions at this stage are not in the best interest of our country.
Okay.
And once we're able to do that, I believe we can get to.
Okay. From where you sit in a minute, can you tell us, in terms of the capping the ministers and not bringing ministers from within Parliament, what should be the cap? And capping Parliament, the suggestion is that it should be 77. It shouldn't reduce. It should be 277. You shouldn't reduce it. And for the ministers, it should be capped at 55.
55.
Yes.
Yeah, with the ministerial thing, I think we've all been talking about it. In 2016, when we were writing the manifesto, the number of sector persons in that room was very small because we were thinking of a lean government. Immediately after the election and the overwhelming results that came, I think the president then was overwhelmed. Then he thought, why don't I maybe sort of reward constituencies and who voted for us? And he changed his mind and he continued adding on to the numbers. That is where we reach, and nothing would make him change his mind. Even reshuffle, he will not buy it. So this is nothing new. I think we have all spoken about it, that the number should come down.
All right.
So if it is 55, I think it will have a very large support.
Okay.
As for the parliamentary thing, if you look at how the constitution is drafted, is that after every census or so, you've got to look at the numbers again. I think every 7 years or 10 years we are doing it. So does it mean we keep on adding numbers? It doesn't make sense to me.
Right.
That thing should be cut because they can't even find, as we said, Chairman Samson, if the members find place to sit. And they're thinking of going to build new parliaments and things like that. We should stop it somewhere. I support it fully.
Thank you very much, Aiko, to there. So let me come back here so we finish up. So, Clara, do you have faith that your work eventually will bear fruits?
Do I have faith? Yes. And the basis of my faith is the Ghanaian people and what we've heard so far. We've made recommendations, and I always say that recommendations are suggestions. So these are the suggestions that we make for our collective benefit. The people can agree or disagree. And so far, this is not the first time we've talked about them, but so far, anytime we've talked about the recommendations that we've made, it has generally been accepted. It's generally received public support. Even around this table, everybody agrees that we need a cap on ministers. For example, everybody agrees that we need a cap on Parliament, for example. I always
should go.
Exactly. So there is general consensus on the recommendations that we make. It reflects the diversity that was in the committee. So once there is, what really we now need is political will. So once the president-elect is committed to the effort, I believe that for all of our sakes, it would bring at least all the work that has been done before this committee, all culminated in the report that we've produced. And then, of course, we hope to see that going forward, something comes out of it. And if you give me just 30 seconds, I want to mention, even though you did, I want to mention the men and women on the committee and the institutions that they represent, and then it's
been highlighted, so people are seeing it.
Okay.
And they're seeing the names all there. I mentioned some of them.
Okay.
I'll try and see if those I didn't mention, I'll mention them as well.
Okay.
Right. The Honorable Chairman Sebonsu, so you must be sort of retiring a happy person that you led this process that eventually will add to refining the CRC's work and eventually lead to a new, call it a new constitution somewhat.
Well, yes, but it's not a singular effort. Let me also indicate that at the very outset, we try to build consensus. And I think the VOMO raised issue about the involvement of some others. It wasn't about resetting. It was really bringing everybody on board to continue. So the Professor Fiajo-led committee's report is aligned with what Clara T. Kasati has done. It's aligned. I wouldn't want to say that that report is in the belly of this one, no. But it's aligned and it's really encapsulated in that report. So everybody was brought on board at the very beginning. All that we have tried to do, as the Honorable Husseini Inusa succinctly put it, is to try to improve our governance architecture to be able to deliver so that the people of this country would benefit from the dividends of democracy. As the preamble of the Constitution provides, and I think you try to quote from that we resolved when we had that referendum to give ourselves this Constitution. And we said we wanted to establish a framework of government which shall secure for ourselves and posterity the blessings of liberty, equality, opportunity, and prosperity. I wanted to do this in a unified and stable nation. So all of us are stakeholders. I wouldn't say that this is a final product. It cannot be, or it may not be. But I will submit it to the president, and I believe that all of us will rally around it and will continue the process to really consolidate whatever has been done. And the people of this country, as stressed by the president, would have a buy-in. Because after all, this is the first constitution that directly has been approved, or if you like, ratified by the people of this country. They must have the final say-so in the final product. If the final product is going to be a referendum of a reviewed constitution, so be it. So I think that is how I see it. So it's not a joy to myself, but a joy to all the people who really were with me in getting to where we are.
There are those who say John Mahama, one term to do is the best opportunity we can ever have to have this done.
Because it doesn't have any stake going forward. And nobody would accuse him of having manipulated the system to satisfy himself. So I think he has a very unique opportunity to really take us to where we want to get to improve our governance. To improve our governance, and not only just for that, but to ensure that this constitution becomes development-oriented. Unlike, the first instance, it was to stabilize the administration. And Clara sent us through the various hiccups that we have as a nation suffered. Now we are stable. I think we are plateauing. How do we improve on it?
Yeah, Professor Fiajo's, the theme was from a political to a development constitution.
Absolutely.
All right.
Absolutely.
Do you think that if this chance was missed in John Mahama's period, we will not see it again?
I'm no octopus Paul, but I don't want to believe in the first place that we are going to miss the boat. I think there's a lot of goodwill, and John cannot afford to miss the occasion, which is why I'm in alignment with what Baka Vomawo has said, that they want to keep the issues on the front burner. I would want to plead, though, that the first 3 months, he is talking about January, but the first 3 months, the president will have to put in place his cabinet. And Parliament, there's not much time. Parliament then will have to work on approving the ministers and so on and so forth. And then the budget will have to be fashioned for the country. So that the first 3 months will be a difficult terrain, a difficult period. But after that, maybe April, May, June, if he wants to do it, I'll really align with it. Except that if it is just to serve as a reminder to him that we want to bring, to build a groundswell of opinion to carry this forward, I may agree with him.
All right.
In terms of the real mobilization, I'll plead with him that perhaps April thereafter will be a much better date.
Great. And he just mentioned what Bakavomawo just said that was going to happen and that they are doing, and that will be at the British Council on the 21st of January 2025. Let the conversations continue in this direction. My guests have been Clara Kolega Berry Kasati, Chairperson, Constitution Review Consultative Committee; Oliver Bakavomawo is Constitutional Rights and Policy Strategy Advisor, Democracy Hub; Inusa Hosseini is former MP, Tamale Central and former ranking member, Constitutional, Legal and Parliamentary Affairs Committee of Parliament. He's been a minister, 2 different portfolios. Ni Ayikoyotu is former Attorney General and Minister for Justice, a leading member of the New Patriotic Party. Oseiche Mensah Bonsu, MP Swami, immediate past majority leader, and he's the man with executive oversight of the CRCC's work. I'm Samson, Lardy, Anyenini. Join me tomorrow on my favorite show.
Current Minister responsible for Presidential Affairs.
Currently Minister of State responsible for Presidential Affairs. And we say he's the leader emeritus. Tomorrow, join me on my favorite show, The Law. That's the weekly legal education that I bring you on Joy News at 2 p.m. together with Mamavi Owusu Abuaji Esquire. We'll be talking about the transition law. So we'll tell you everything you need to know about the transition law and what can be done, what cannot be done by the outgoing and incoming administrations. I'm Samson, Lardy, Anyenini. Have a good afternoon. Thanks for your opportunity. And season's greetings to all of you. Thank you for staying with us all the year.